Good afternoon, good afternoon, good afternoon, law nerds. It is Tuesday, it's August 27th, and we're going back into court for the second day of the Kouri Richins preliminary hearing. She is accused of the attempted murder and ultimate murder of her husband. This is a case out of Utah. She's accused of lacing a sandwich and then a Moscow mule, along with forgery, fraud, not wire fraud, that's Tom Girardi, Emily. That's the lawyers. Forgery, fraud, mortgage fraud is what I meant, and more. So we are going to be tuning back in. However, we missed the last about 10 minutes of the hearing yesterday due to issues with the pool feed's parent company. And because of those issues with the pool feed parent company, we did not get to finish that, while it never should have happened. And the local pool camera has assured me, the local pool network has assured me it won't happen again. That was not on them. That was on the parent company. And don't worry, we're going to be dealing with that in the future, because the local outlet is like, oh no, that puts our pool status at risk. I'm like, no, I know, I'm letting you know that this is what the parent company is doing. You know, media fighting media. It is what it is. The new media, legacy media fight continues. So it shouldn't be an issue today. If it is an issue today, look, all of you that are in the app know what happened. I messaged you in the app so that you can stay in the loop. If you don't have the app yet, maybe now's the time to get the Law Nerd app. Emily, are you going to say it's the way we can keep in touch with everybody? Yes. Valkyrie Art said, are you going to get yeeted again? Shouldn't. Absolutely shouldn't. But can one ever know what's going to happen with the interwebs? No. But it shouldn't happen. So today we are going to finish the last 10 minutes of court yesterday, and then we are going to get into the end of the preliminary hearing today. It won't be going to preliminary hearing tomorrow. They are just about done. So with all of that, we need to go to court, and I can't wait to see what happens in this case. Look, it's not unusual. It's most unusual for a preliminary hearing not to get held to answer. It is likely that it'll get held to answer. It's likely that the judge will rule today. It's likely that this case will just move forward to trial. There is more than enough evidence here to hold this to answer. The judge has been very much lenient in allowing the sides to argue. There's, of course, no jury here. So the sides get to just kind of lay out their theories of the case. And we'll see how much the defense will preview their theory of the case. That's what I'm really interested to see here. We know what the prosecution's theory of the case is. They've signaled that in the motions that they filed. I'm really interested to see what the defense says in argument, how the defense argues against whether or not there's probable cause here, because at the end of the day, this is really going to get held to answer. If it doesn't, I will be shocked, because there's probable cause here. So we will see what the defense argues and how much they tip their hand. Sometimes we just get defense attorneys at prelims saying, Your Honor, the state has not shown enough evidence for probable cause. And then they might say this affidavit isn't sufficient or that doesn't meet this element. We normally don't get a ton of information, and I'm wondering how much information we'll get here. So with all of it, let's go ahead and go to court. I've said that like 3 times. We're going to roll the intro. We're going to go to court. I can't wait to see you guys. I love live court. We're back in court on Thursday in Idaho. So we've got a lot to do this week. Oh boy. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Let's go to court and see what happens today. I've got our audio all gained up. Hopefully it sounds awesome. Fingers crossed. And we'll go from there. Let's roll, y'all. And I saw some of you asking in the chat, I have media access to this court. We are allowed to use the pool feed. The pool feed is not copyrighted. This is not a KUTV issue. This is very much a parent company issue. And that is something that sometimes the robots do. So this is not beef. I do not have beef with KUTV. It's annoying, but again, sometimes corporations are going to corporation. it will be fine. So right now we have the Miguelino, we have the forensic accountant on the stand. So it is not the homicide investigator. This is the redirect of the forensic accountant that we're going to be starting with. This is the end of the day yesterday before we get to argument today. I forgot to grab my notebook. So we need to make sure that we have the forensic accountant up. That is who is on the stand. And we have gone through the direct examination and the cross-examination of the forensic accountant. Just for a quick bit on that, the testimony yesterday of the forensic accountant was that Kouri Richins was swimming in debt in her real estate company flipping houses, that she had, unbeknownst to her husband, it seems, taken out a home equity line of credit or a HELOC on their home like a second mortgage and was paying that back out of her personal account. But that Eric Richins brought that up when he met with a divorce attorney in October 2020. When he met with that divorce attorney, the notes from that attorney that were brought in court through this witness yesterday were that he did not know that that home equity line of credit was taken out on the house. The house is only in his name. He purchased that home before he got married to Kouri Richins. That is his separate property before the marriage. Then they got into a bunch of information about whether or not he knew, he didn't know. He knew by October 2020, but didn't seem to give permission, hence the conversation with the divorce attorney. It came out that Eric moved all of his assets into a living trust. Kouri was not the beneficiary of that trust, meaning that if something happened to Eric, everything would go to his kids and his sister would be in charge of that trust. It seems that Kouri did not know that. But the defense insinuated in cross-examination that she might have learned at some point before Eric Richins passed away. So the defense attorney in cross-examination went into the back and forth of, did Kouri Richins put this much money into their joint account? And did Eric Richins put this much into the joint account? And during that cross-examination, the judge kept cutting the defense attorney off and saying, this is calling for a legal conclusion. At one point, the judge says, I see the prosecution objection. He's like reading the prosecution's face. And as Bloodworth is standing up, and the judge is like, I see that you're objecting to calls for legal conclusion before the prosecution says a word. And the court goes, and that is sustained. And then the prosecution goes, I'd like to be heard. He goes, your objection for calls for legal conclusion is sustained. And then Mr. Bloodworth sits down and is like, meh. So we are really just moving through a preliminary hearing and seeing from the forensic accountant what financially was going on with Kouri Richins, what she thought she might get from a life insurance policy. The life insurance policy, the third or fourth one on Eric Richins, went into effect February 2nd, 2022. He passed on March 3rd, 2022, with the attempted murder charged on February 14th, 2022. And then apparently there's an email from Kouri to the insurance company being like, what's taking so long? The death investigation, Kouri. The life insurance company finds it sus when there is life insurance taken out, in the weeks prior to somebody passing away, when they pass away from a overdose, but the crime scene doesn't show traditional signs of an overdose and they don't have a known issue with narcotics. And so all of those things raise a really big red flag for the life insurance companies, who it seems to be the goal is to not pay out. If they don't have to pay out, that's like part of their business plan. So hopefully that was a good road so far of where we are with this witness. We're in court. Let's hear what they have to say.
Investors were not going to get their money out of that particular property. So their trustee, their investment was transferred to a different property where there was room for them to be repaid.
This should be the end of cross-examination.
So some of these subsequent sales.
I needed to back up. I wanted to hear the beginning of redirect. That should be, is he just getting up? Oh, I thought I had it queued up. There we go. She's sitting down. All right.
Mr. Burr, is there any redirect within the scope of process?
Yes.
All right.
Ms. Karrington, you were asked about...
So we are on redirect.
Yes.
Where we ended Brooke got so rudely interrupted yesterday.
If we're measuring success, as
She took a lot of issues to being asked about the success of Kouri's business.
that go into purchasing, rehabbing, taxing, etc., the flip. That is a measure of successful flip. Were these purchases in subsequent
The
sales
swinging of the camera is always tough for me.
If they were
I don't
sold, if that's your measure of success, then they were sold, so that would be successful. There were
I love the
several
forensic accountant
where-
is just like, I mean, how do we define success? The houses were sold, but she was swimming in debt and was paying like $300,000 a month to service loans. I mean, I don't know if I would call that success. I would call that like the level of anxiety hearing about it gave me. So when they're talking about what is success, the forensic accountant's like, I mean, I guess if selling the house is a success, what if a 3% profit margin is success? What if it's 15? Like, what if it's not servicing loans at $300,000 a month? What is success?
Instances where the investors were not going to get their money out of that particular property, so their trust deed, their investment was transferred to a different property.
If the
where
investors
there
don't get their
was
money
room
back,
for
they
them
don't feel like a success.
to be repaid.
So some of these subsequent sales did not even meet the investment that went into them.
That's right.
That's not successful to the investors.
So at the time of the defendant's death, March 4th, what was the summary of debt owing? Do you have the
Yes. 3 of the homes had recently, prior to Eric's death, had been sold for about $170,000 in net proceeds. And then Mrs. Richins had retained, I believe, 5 properties at that time.
This is prior to the
HELOC
death.
was over its limit. It was at $252,000 dollars on its balance. Her credit line at PenFed had been exceeded. Her credit line at America First was about maxed out.
The HELOC was overdrawn.
And
Personal credit maxed out.
She ended the year in 2021 in the hole. I think in her 5244 account, she was in the hole $15,000, and in the 6577 account, she was in the hole $22,000. There just were no resources.
So as we're ending 2021, this matters because the attempted murder is charged on February 14th, 2022. The murder is charged on March 3rd, 2022. The boyfriend, paramour, lover, whatever comes into the picture texting with Kouri in November of 2021. So when we get to the end of 2021, as I make the Titanic analogies where the iceberg is the debt in this case, as they are speeding towards debt, and Kouri is speeding towards not being able to sell these houses that she's flipping fast enough, she has overextended the home equity line of credit that she took out, they say with what seemed to be a forged signature of her husband. She took out that home equity line. It was overdrawn. That's a $250,000 home equity line. She is maxed out on all of her personal assets, credit cards, debt. Her 2 bank accounts are overdrawn, one by $15,000, one by, what did she just say, $20,000. And then she is closing out the year in the hole, but was closing on a $2.9 million property. And this is from testimony yesterday, was closing on a $2.9 million property that needed $3+ million to rehab it and flip it. And that was a property that she told law enforcement she was celebrating when her husband drank the fatal Moscow Mule. So even though she has the weather reports right in her hand, she has her hand on the accelerator and she's like full steam right ahead into this iceberg of financial ruin, and she doesn't seem to know. Kouri doesn't know. Kouri doesn't know. Kouri doesn't know. Don't tell Kouri. Kouri doesn't seem to know that if her husband dies, she does not get half of his business. She does not get the life insurance policies. That all now goes. She doesn't get the house. That all now goes in a trust governed by his sister for the kids. Remember, as yesterday's hearing, they were talking about the forged bank accounts showing that her business account had $15,000 in it, which is nothing to sniff at, but in this high liquidity business, she probably needed more. Her husband's bank account had over $700,000 in it. That's her husband's business account. He's entitled to half of that. So we are looking at the staggering amount of debt as we're moving forward in this. So we are finishing up this last witness from yesterday's hearing because we were so rudely yeeted by corporate.
When you say there's no resources, so then she's unable to service all the debt she's acquired.
That's correct. And at that time, again, it's kind of mix and match to try and figure out how much debt load she had. She owed about $4 million on, well, let me restate that. The trust deeds associated with the property that she retained were about $4 million. So she probably owed a little bit less than that. And then the personal property loans, the accounts payable loans, I believe her balance at that time was about between $500,000 and $600,000.
Somewhere then between $3 million and $4 million is her total debt load she has at the time of March 4th, 2020.
No, it would go the other direction. So she had
He's like, no.
roughly $4
The other way.
million in real estate
Locked
that
up.
she owed on, and then another $500,000 to $600,000 in those personal property loans. So $4.5 million, something like that.
You mentioned the HELOC and talked
The home equity line of credit.
Defense counsel. Do you know?
I forgot I had this sped up yesterday.
$50,000.
The question seems slower today.
Principal in October of 2020. Were there any other payments you're aware of that were substantially beyond just paying the interest?
No, they're pretty much the minimum payments for the rest of the.
She was servicing the loan interest only to the extent of like $300,000 a month in interest only. She wasn't paying down these loans. That was barely servicing the loans. When I thought that my student loans, when I was freshly out of law school, made me want to barf on the regular, I can't imagine dealing with this type of debt. I don't think I could get out of bed in the morning. This would absolutely cripple me. But she's just rolling with it. It's so Murdoch-y. It's like, yeah, it's gonna be fine. I mean, I can't like, it's gonna be fine.
Life of the loan.
When did she stop drawing money on the loan?
When it maxed out, apparently.
Do you mind if I look at my notes?
It's just so
In
wild.
October of 2021 is the last draw of $2,300 payable to Kouri Richins Realty.
And why didn't she just take some more out of there?
Objection to speculation, Your Honor.
I think he's asking a financial question.
Also, she's an expert. It's a prelim. She can speculate.
The balance of that account, the limit was $250,000, and as of that time, the balance was $253,199.25. So there was no room to draw more.
The amount of debt, man.
Did these lenders that you're aware of?
She had over 15
realize,
houses in 2021. It's too much
for,
to
the
flip.
Defense Network, and she was taking out these loans, accounts receivable.
It appears, yes.
Well, her net worth wasn't exactly her net worth because she wasn't using her bank accounts.
They did.
Okay, so how much did she have in artwork?
I don't recall any artwork listed.
Okay, how about jewelry?
I don't recall any jewelry listed either.
Property. It was just property assets. Again, the Titanic analogy works in this situation because she's barreling towards financial ruin.
Which bank account were the payments made to the top insurance?
This is how people ended up so upside down in
Those paid
2008.
from the joint checking 2204.
Okay. And that's distinguished from the last one, the one made on February 4th, or entered into on February 4th, with apparently no notice to Eric. That was paid from which account?
From the 6577 account for K versus Realty.
I had nothing.
And that's the end of redirect.
Ms. Nestor.
Nothing, Your Honor, thank you.
Ms. Karrington.
No recross. This witness is done. This is the end of the day yesterday. The forensic accountant. Put your glasses back on, Your Honor. Oh, Emily, be responsible. It's okay. Dr. B doesn't watch the streams. I love it when he puts his glasses on too. But we are at the end of this witness. Your Honor, I'm going to let you finish. I promise. But we are, I interrupted myself with the glasses and I don't know what I was going to say. The end of the witness. Oh, this forensic accountant added to her testimony from the detention hearing. That is up on the channel if you want to watch it. The reason it was added is because additional charges were added against Kouri Richins after her arrest. When she was originally arrested, they charged her with, and that's what I was just pulling up, they charged her with the murder and a couple charges with regard to possession of the fentanyl. But after the arrest, after all of the records came in, after all of the bank records, subpoenas, and the rest of it, they charged her with the aggravated murder, then the attempted murder, a number of the narcotics charges, the mortgage fraud, the fraudulent insurance claim, and then the forgery counts. So that's when they added those counts. So they added back the accountant to build on to the cut and pasting of those bank documents from Eric's business and her business that she was submitting to the banks to obtain those mortgages. So the 2 counts of mortgage fraud and 2 counts of or the 3 counts of forgery for making those, and then the false fraudulent insurance claim for that life insurance that she was making claims on. So that's what added counts plus that attempted murder. And that's why this forensic accountant needed to come in. The forensic accountant, if and when this goes to trial, I think is going to be maybe a couple days of testimony and illuminating testimony. She was a great witness. I really like the way she explained things. I found her easy to follow at the detention hearing. I think she's great here. Look, forensic accounting is kind of great. She's like, I got the deets and the receipts, screenshots, fucking everything. She's got the emails back and forth to the mortgage company. How do you prove the mortgage fraud? It's in the email. She's like, here's the emails, here's the bank records, receipts. What else do you need? And she just explains the receipts and then has them all lined out in a color-coded chart, and we stand. Like, Emily, tell me you worked for your white-collar crime professor in law school and loved doing complex fraud cases. Guilty. Why? Because the paper, if you can explain what's on the paper, everybody goes, ooh, tea. You can explain what's in somebody's bank account. They're just like, I want to know what money she was spending on the boyfriend out of the bank accounts. I want to know. When it goes to trial, we might find out. But I love a forensic accountant, and I thought this one was absolutely great. So let's see what the judge has to say at the end of the day yesterday, and we'll go from there.
Mr. Bloodworth, what's the plan?
Your Honor, the state does not.
Mr. Bloodworth, what is the plan? Look, he feels like he should either be from Sesame Street or from like, I don't know, Darkwing Duck or something, because it's like Mr. Bloodworth. That's his real name. I love it.
Does the state
He
rest?
said no more witnesses. The state rests.
Okay. Ms. Lewis, Ms. Nestor, Mr. Ramos, is the defense going to
They just named off a fleet of defense attorneys.
be calling any witnesses?
No, Your Honor, we won't be.
No witnesses for the defense. At this point, the judge is like, why the fuck did I set aside 3 days for this? Because y'all told me the defense is like, we're going to have witnesses, and the prosecution's like, we're going to need 2 days. And in a day, they're like, so we're done. Cool.
It's late. There's a lot of information here and a lot of counts. I'm disinclined
To acquiesce to your request.
cram that in today.
Well, you would
What's
need the
a
spit.
reasonable time to come back to tomorrow.
We don't want to cram it in.
Ms. Richins wants to waive her right to testify
There's no way she's testifying.
and argue about the showing of probable cause.
Yes. So that's what the court does. They resume the hearing today, and that's where we're going to go. But we're going to let the judge talk because we love him.
Whatever time it's like.
You're allowed to have a preference.
For those of you that don't love the judge, I don't mean to impute your feelings. I really like this judge. And after Judge Bev's sitting there spinning her glasses for 10 weeks, this judge is like, I got my notepad. I got the details. I'm ready to go. I love him.
Later the better. Later the better.
Do you want to do it in the afternoon?
Your Honor, if I couldn't love you anymore, a judge that's like, what time do you want to do this? And they're like, the later, the better. He's like, we could come back in the afternoon. I love him. I had judges who were like, I get to work at 8 a.m. That means everybody gets to work at 8 a.m. This judge is like, whatever's clever for y'all. I got it.
10 a.m. Mr. Bloodworth?
Yes, sir.
Okay. Very good. Mr. Ramos? Yes, sir. All right. Ms. Richins, we will retire for the evening. Court will be in recess until 10 a.m. tomorrow morning.
Perfect. Court is in recess. All right. Let us move on to today's hearing. All right. I'll make my notes. And for a couple of you asked, I'm still using the Remarkable. I just forgot to unplug it. I screwed up my pen yesterday, but it's fine. For those of you complimenting the hair, thank you. I appreciate the compliments. It needed a little heat today. So you'll see the before and after from the podcast recording when the podcast goes live tomorrow. So we are going to hop back into court today. A number of you in the chat have mentioned that other channels have had issues with the same parent company we had an issue with yesterday. If anything happens, A, I will fight it. If it keeps happening, B, we will lose our minds. But Law Nerd app, and I will keep you in the loop. You're not taking us out on something that can't be copyright protected by copyright claiming it. That's not what we're doing. We've got the Law Nerds, we've got an app, we've got all of them there. Stop. All right, let's go to today's hearing. They have said that they are going to come back to argue. So we are going to hear how the prosecution views this case, how the defense hears this case, and the rest of it. It is not law and crime. The KUTV has the pool camera. I am part of the pool for this case. We are allowed to use the pool feeds. Everyone's allowed to use the pool feeds. There is no copyright in them. KUTV has the pool feed. It is the parent company for KUTV. And KUTV has said, this isn't us. We will let digital know because this shouldn't be happening, because KUTV does not want to lose its pool feed access, and their parent company probably has a third party company that is the people doing it, who just obviously don't understand how like any of this works in court. But it's not going to stop it from being a problem. Tracy asked, why does Kouri have so many lawyers? Probably because the public defender's office said that they needed that many, because this is a murder case heavily in dealing with narcotics. And so you're going to need lawyers who understand all of that. But it's also a financial crimes case. It also has a lot of cellular digital evidence. So they're going to need lawyers that deal with all of that. Leafy, KUTV has been incredibly cool. It is not them. It is the parent company, and they don't have control over that. It is the corporate overlords that are the issue. Emily, Q fuck authority. Hold on. No, what? No, we're not going to play Pennywise on stream. Then we will get taken. Then we'll be messing with both the large media corporation and the music industry, and we will absolutely end up with our stream taken down. So Lizzie asked, she has public defenders. Yes, she had privately retained attorneys. Those privately retained attorneys had a conflict because of other things going on in the subsequent cases. There are multiple civil lawsuits as well, and had to step out. So let us get back to court. Hopefully the audio is, less potato. Let's gain that up. Your Honor, good morning. We're all here for day 2 and for argument. Best part.
What happens before?
KUTV did a really nice job of gaining that up when they put this up yesterday, but I don't think theirs is up yet today from the pool. So we are going to be a little bit more potato-y today. Hopefully it will gain up soon.
Before a charged event and what happens after a charged event is probative of the event, particularly in.
All right. The media order on this case has been pretty strict that they can't even start recording till Kouri's sitting, but it seems like this cuts in the middle.
Should fully consider it. What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me maybe explain in some greater detail.
Sure.
So it seems that we are coming in just at the beginning of the prosecution's argument. Some of that is due to the media order in court. I have gained this up all that I can. And after the other audio, that is tough, but we have gained it up all that we can. And
I guess further to that point,
lies, it didn't work well, and now it's worked. Ha ha. All right, we are free. So he is starting his argument, and we will go from there. There we go.
Attempted
Much better.
homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later.
So he is going through the different charges to argue to hold Kouri Richins to answer. This is a probable cause standard decided by the judge. They went through the aggravated murder, I would assume, first, and then attempted murder. There are possession accounts and distribution accounts. Then there are mortgage fraud, the false fraudulent insurance claim, and forgery. So he's going to go through all of those and tell the judge why there's probable cause. I agree with him. I think there is.
All of the defendant's motive that existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but
He's arguing.
I agree with you. The financial motive.
He's arguing that the proof of the attempted murder is the fact that when it didn't work, she actually murdered him. That is their argument. That is the state's argument and their position of the case. So the attempted murder is proven by the fact that she actually completed that in their view of the evidence. That's not to say that she has been convicted of that. That's their argument. This is a PC. When the court finds PC, they're saying it's more likely than not. They are not saying that she is guilty. They are not saying it's beyond a reasonable doubt. They are taking the evidence at face value. They're not getting deeper than that, but it's just like, yeah, it's likely she's the one that did the thing, so we can go to trial.
That existed in March, existed in February.
The blue is good, though. The blue is much better than the black and white.
But it's not only the financial motive, Your Honor. There is, and I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those sufficiently in hand.
Your Honor, the also...
The prosecutor's like, I can recap the financial motives, and the judge is like, I have those well in hand. Yeah.
The second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman. And their planning for
lover.
the future. And specifically, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him about a month earlier.
I guess what I'm saying is...
Wait! She's talking with the boyfriend, lover, paramour Grossman about raising children. She has 2 children with the victim, raising children and farming with him. So she's like spinning a life with the boyfriend while, per the state's theory, plotting the death of her husband. Ma'am. Those text messages. And for Grossman, I mean, he turned, it seems, everything over to law enforcement. She deleted shit off her phone and they're like, well, we have it on his phone. Ma'am.
You don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for
Okay. So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah, the motives are the same, I agree.
And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th.
The judge
state
is
has shown
telling them to
probable
move on.
cause that she wanted something stronger
I love this judge.
after February 14 and sought it again. Made a reference to the Michael Jackson stuff, which I think at least at the preliminary hearing stage, I can take
Is
judicial
enough.
notice refers to
Propofol.
a well-known event in which someone took a controlled substance and died. I'm tracking all of that.
Okay.
Where I stumble or where I pause is, do we have
Ooh, tell me.
an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
There we go.
So we do.
I like this judge so much. And here's what I like. The judge is, again, the judge is the finder of fact here. The judge has to determine what is being held to answer. And the judge gets to determine that. And he's saying to the prosecution, I don't need you to tell me about this, this, or that. I need you to narrow in and explain to me how we get here. And that is absolutely a fantastic way. And he does it very kindly, not counsel, you've already proven this to me. Like, there are some judges who the attitude is, can you please just shut the fuck up and tell me about this thing? He's very much like, I've heard you. You've made your case well on these things. Explain to me this thing. Help me help you. And I just could not love this judge anymore. So I appreciate it. And he's very, very well familiar with this case. So the judge is saying, tell me how, tell me why, tell me how we know that Eric Richins ingested a narcotic on February 14th, the day of the attempted murder. How do we know that?
Your Honor.
Great question from the judge.
Or attempted to do so.
Sure. Let's kind of focus in then on February 14th.
Yeah.
With the understanding
That's
that
what he wants. Give him what he wants.
She, 2 days earlier, the probable cause understanding that she 2 days earlier purchased fentanyl from Ms. Lauber.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact.
Okay, I'm going to stop. I'm going to stop and let him go. The judge has all the text messages. We've seen the text messages in the charging document. So the things that they can argue to the judge are a lot of stuff we didn't hear testimony on because all those documents the judge has. So you're going to hear things in arguments that you did not hear in testimony because they were just all admitted.
Provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes.
We don't know that it's a sandwich based upon admissible evidence.
So we do.
Tell me how.
The invoice from the Mirror Lake Diner entered into evidence as Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend,
So we're getting into the text between Kouri Richins and her bestie, but we also know she went and bought the sandwich that she gave to her husband. This was a sandwich shop that he very much liked. We know this from the text. And it was Valentine's Day. So is it strange that your spouse would go get you the thing that you enjoy on Valentine's Day? No, not at all. What's strange is to become incredibly ill from it. And that is what they're going to get into.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me, which exhibit is that? We're going to need to talk about that.
I'm gonna need some help on that.
I know what you refer to.
What
but I
exhibit
guess
is
you
it?
can look at it with you.
I don't know.
I might have it in my
IDK.
notes, Your Honor. If not, we're working on that
Okay.
on the side.
But keep going. We can go chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning
For him.
from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms an order.
We know she bought the
receipt
sandwich.
The invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner. I think it's something like a 9:07 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
Thank you to the
We
counsel
then
that
know
swooped
it,
in with the Post-it.
9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of
Wait.
leaving the Camas area.
Speculation from Emily. Was she setting this up so the paramour's her alibi? Like, she gets the sandwich, she gets the sandwich to the hubby, she gets in the car, hubby goes to work, she gets in the car and drives an hour out to go be with her dude. Like, is that so if something happens to husband, she's like, oh no, I was with this person. Or does she really just need to get it on Valentine's Day from not her husband? I've got questions, but I think the reason they're using paramour is because they don't want to assume anything. I think it's an interesting way to go, but I'm just curious if that's why this is all going down this way. Anyway, we're on Valentine's Day. It's the day of the charged attempted murder. A couple of you are asking in the chat, including Mari, where are the kids while this is going on? Probably at school.
An arrival time at some unknown destination approximately an hour from them.
So the boyfriend lives an hour away.
We also know, based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richins with her paramour, Eric Richins has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. We have that text exchange in evidence.
Right.
Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with
His cell phone activity
on his phone and associated devices. All of that is consistent with reaction to gender.
Where's that evidence, though?
I've read it, but I can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction. If any.
Where's
Yeah, so that's
the foundation
toxicologist, not Slauson.
Okay,
for the
thank you.
toxicologist? That's what it is. So the toxicologist is in
Your Honor,
evidence
also in
that lays the
evidence
foundation
is
for it being a
literature
consistent.
from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, in the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richins is sick enough that he's considering going to the hospital, and he's inactive for 2 hours. All of that consistent with fentanyl poisoning.
A lot of this
And
information
then
is in documentary
at that
evidence, but
point-
he's saying 2 days before, she buys fentanyl 2 days before. She's out with the boyfriend. We know she buys the sandwich. We know that he's sick enough that he's considering going to the hospital. It's just like on and on and on. So they're laying out those stair steps or the puzzle pieces that are going to build this at trial. Much more circumstantial. No, at trial, the circumstantial will be more narrowly tailored. Here, they're using documents that the court already has because the court gets to be the finder of fact at the prelim. And the standard is
The defendant's own words are
fairly
kind of
low.
important here because he texts her, right, of his illness, of considering going to the hospital. And what she says is chilling.
What'd she
She
say?
says, take a nap. And then she doesn't check on
Sir, that's new information. He texts her, I'm feeling sick enough. I think I need to go to the hospital. There's new information in that sentence. Look, ma'am, did you get him some black-eyed peas with that sandwich? Gone full Goodbye Earl.
consistent with fentanyl poisoning.
I rewound it. I had to
And
hear it
then
again.
At that point, the defendant's own words are kind of important here because he texts her, right, of his illness, of considering going to the hospital. And what she says is chilling. She says, take a nap.
Wow.
And then she doesn't check on him for 2 hours. She doesn't
come home?
She doesn't text. She doesn't call. She doesn't check on him. Their next communication is 2 hours later when Eric Richins checks in with the defendant.
Wow.
Notably, throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events is consistent with a consciousness of guilt.
Take a nap. Oh boy.
She had texted on February 11th and 12th significantly with her drug
I want to write the opening statement for
during a
this
time
trial.
frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone.
And the texts
She
are deleted
texted
from
with
her
the
phone,
drug
but not
dealer
his.
30 times, about 30 times with Mr. Kouri Richins' testimony. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times.
I mean, was she trying to get freaky?
Eric Richins texted the defendant a photo
I wonder if the defense will argue
while
that.
he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richins' phone. That is in the moment consciousness of guilt.
Oh
The
boy.
next day,
Forgive me, I don't recall testimony from Mr. Richins or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but
very young.
okay.
he's saying it's day of consciousness of guilt. That's a great catch by the judge. The prosecutor's arguing this is day of consciousness of guilt. And he's like, I didn't hear testimony about when those things were deleted. They could have been deleted February 14th, 15th, 17th, March 1st. We don't know when they were deleted, but we know that they were deleted before her phone was seized. So the prosecution saying this is day of consciousness of guilt. The take a nap might be, but the deletion of the text message, the court's like, I'm not convinced that we know that it's there. For those of you that are asking, don't understand the Black Eyed Peas references, it's a reference to the Chicks song, Goodbye Earl. I am not comparing the victim in this case with Earl. In that case, I am comparing the mode of death to the two, because the take a nap is very similar to some of the lines in the song. So, you know, that.
The next day, after Valentine's Day, February
Musical
15th,
references or movie lines are generally what it is.
The defendant lamented to her paramour, if he could just go away, life would be so perfect. And then 2 weeks later,
she's texting her lover, if her husband could just go away, ... life would be perfect. Ma'am.
lamented to her paramour, if he could just go away, ... life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday.
What's
On
the date of that
Friday,
text? Hang in there till Friday? Well, life sure is different in custody, isn't it, Kouri? Oh, boy. I am floored.
If he could just go away.
I had to back up. I'm gonna shut up. The prosecution's spilling all the tea.
And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Kouri Richins was dead.
Ma'am!
We referenced Exhibit 8, the text messages that the defendant.
No wonder those text
sent
messages
to
got
the
deleted.
I don't think that's it.
No wonder
So
those
right.
text messages are gone off her phone. Thankful to the lover here who didn't delete them off of his phone. Oh my goodness. Hang in there till Friday. Fucking hell.
Well, Your Honor, it would be found in the Celebrate extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot, it looks like a download.
It's in the Celebrate.
Let's get there together. I need the exact language.
The
of that.
jury is gonna be like,
It would be
what? Oh. Y'all, I see you saying code red.
Okay,
I think
got
we
it.
might
So
be closer
this
to code
is-
green.
You got to be specific about.
I think it's audacity, but this is solid evidence for the prosecution.
This. A
Tell me
June
everything.
18, 2022 communication, correct?
yes, Your Honor.
And the
it's
court's
June
like,
18,
get me the
2022.
receipts.
I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this incident. This text is a discussion of the Valentine's Day 2022 incident as put forth publicly in civil filing.
Well, now I need to go find the civil filing for that.
I have some questions about this when you're done going through the evidence.
Okay.
Tell me
I also have
everything.
questions about the February 15 text messages. So just put 2 pins in those.
There's text messages from the
I'm
15th.
not questioning the existence. I didn't know that they exist.
No, sure. That glance was to get it.
I'm going to answer this question in the chat because I can. Art by Julie E said, why murder, not divorce? I don't understand these people. Kouri Richins was well aware that under their prenuptial agreement, if they got divorced, she did not get the house. It was in his name before they got married. She did not get an interest in his business. It was separate and specifically lined out in the prenup. So that's part of why we have all of the financial motives coming in like we've seen in other cases.
Copy whatever the
Okay.
February 15th text was.
Well, it's if you would just go away, ... and then
Yeah.
I promise we'll be together on Friday or worse to that effect.
Yeah, yes, Your Honor.
Okay.
It's 2 text messages, Your Honor. There are 2
We
there
can
that
discuss those.
have a lot of
Text when we're both
context.
Looking at them.
Okay.
The text to her the text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages to Eric himself. We know that to be false
Don't
from
lie
her
to
text
the
messages
bestie.
to her paramour. We know that to be false from the navigation screenshot.
Don't lie to the bestie.
Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him.
Oh, the friend group must have been talking.
The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen. Because she knows those facts are indeed true and indeed inculpable.
Eric's friends in text messages back and forth with him talked about him breaking out in hives and other things. So the group must have been chatting when she's telling her bestie, we were all here. None of this is real. We were working from home together. Oh, she's just fascinated rereading the text. She's like, well, I deleted these off of my phone, so I guess discovery is the best way to refresh my recollection.
Discuss this text, or should I continue on with further answering your question?
I'd like the text discussed further.
Homicide charge kind of relates directly.
I would like
to
the text.
homicide charge.
Well, let's pause here for a second.
Yes.
Tell me, Your Honor.
We also skipped over or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor,
The court asked Bloodworth, the prosecutor, can you point out the text where Kouri was texting CL, the dealer, for something stronger? It's my remembering from court filings that after Valentine's Day, she texts her dealer and says, I need something stronger. And the court will likely use that when we're looking at building the puzzle of, was this an attempted murder? If somebody gets very sick and then does not die, and then you are reaching out saying, can I get something stronger? The court is allowed to use that information to kind of fill in the gaps of the circumstances here. So he's asking the prosecutor to look for that.
I don't know that I know a precise date. It's somewhere.
Somebody on your team does. He says somewhere around 25th.
So,
February 25th. I'm taking notes real quick.
I think it was 12 days later, right? Okay.
12 days
And
after.
Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide
Is the homicide.
is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day
Didn't work.
wasn't strong enough, which is why she went back and asked for something stronger.
Oh boy, those texts.
But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same.
The
But
text.
she learned. She learned she needed something stronger. She
And
also
more.
learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once.
Not in the Moscow
She
Mule?
says that in her journal.
Not in the Moscow Mule? What does she say in her journal? In a shot? Oh my. Oh my. She says it in her journal.
She administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49.
What's it say?
And she learns that it takes a truckload of fentanyl to kill him. She learns that one bite in a sandwich isn't enough. It has to be stronger, it has to be administered at once, and it has to be a lot. And that's why Eric Richins' toxicology shows 5 times the lethal amount in his blood and 20,000 nanograms per milliliter remaining in his gastric fluid.
So still in his stomach.
The attempt and the homicide are connected in MO.
You surprised to see your journal in this context, ma'am? It looks like you're a little surprised to see your journal. You thought the only writings the public would know about was the children's book about grief after all of this. You didn't get arrested for a year after this homicide, and they have a journal?
Bruh.
Not only the Googling of the luxury prisons for rich people, but the journal. Chat, I agree with you. The just audacity of it all. So yeah, we're gonna go. I don't love the way I look when the lights are green, but we're gonna go to code audacity. I thought we knew quite a lot about this case after the detention hearing. I was shocked when she throat punched her sister-in-law after finding out that she was not the executor of the estate. I was floored. There is so much new information here, and this isn't even all of it. Oh, I can't wait to hear the defense argue. I am riveted. Riveted. I need to know everything that happened.
And lessons learned.
Yeah.
Oh, my white balance hates this.
Let's imagine for a moment that everything through February 15, February 26. stays the same. Imagine Eric Richins is still alive. The text message on June 18
There we go.
gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
I think you would.
We would, Your Honor. And I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that you ordered lunch from Miro at Diner. We have him having a significant enough event that he contemplates going to the
I
hospital.
like this judge.
We have text messages on February 15 that draw reasonable inference that she wanted it dead. We have her out looking for something stronger when he did not die on February 14.
Right. The judge is trying to be delicate with that.
We have the medical foundation. The difficulty is, right?
I've killed my white
This
male.
just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor and Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge.
And that's not what he wants to
that
do.
says some medical event around the same time.
Right. And he's like,
But
we're not
here
doing
you
that.
say,
And the spouse dies 17 days later under very, very similar circumstances, same medical connection between the two.
and is it 404 that lets me connect the dots here?
I don't even think the court has to go to 404. I think the court can connect. I mean, certainly it's probative. So, yeah, certainly it's relevant. I guess the court could connect the
I
dots.
don't think 404
Probative,
lets
but,
you make that jump.
There's no doubt, especially, returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic
It's the
violence
totality.
defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
It's equally present. It's separated by merely 3 weeks.
correct.
Yeah.
It's equally as strong. Now, Your Honor, the court raised, that this isn't speculative, and it's not.
I think
And
the
Schmidt
texts
kind of
are
talks
instructive
to
here.
The notion, the point, right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just
Any
to make sure that the state's record,
reasonable.
the most reasonable inferences, just to make sure rather that the state's inference is reasonable. And we leave the most reasonable inference question to the jury.
Okay. All right, so if you've got probable cause for count 2, you've got it for count 4.
Yes, sir, I
That's
think
what he's saying.
two goes that, or 4 goes that, 2 goes.
Count 2 is
I
the
think I
attempted
understand the
murder.
state's
Count
position here.
4
You will, of
is
course,
a
get the
distribution
last
charge on the
counts,
narcotics.
all counts, but certainly counts
Just
2
pull
and
this
4.
up
I
so
have
we
some
can go through
questions
this again.
regarding some of those unusual counts.
Yes.
I love it when the judge asks questions. He's like,
Bear with me for a moment.
he's the finder of fact. He gets to ask questions. How do we get here? Why is this
All right,
not making
count
every
these
possession case a
For insurance fraud,
attempted murder?
what is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Count 8 is one of the insurance fraud cases. It is insurance fraud from January 29,
Yes, Your Honor,
2022
and
on the $5,000
The
policy.
statute under count 8. The
The
insurance
court says I'm
fraud
there on the other
statute
one.
has
How are we there on this one?
different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Oh, so these are in the alternative. Oh, they're different sections.
Well, for count 7, right, it's either it could be the forged signature.
The the court and the prosecutor are talking about counts 7 and 8 in the amended complaint. Counts 7 and 8 are under different code sections, so they could be in the alternative. Count 7 is 76-6-521 2B1. Count 8 is 76-6-521 2D. So there are different subparts to that on count 8. And I'm just going to read you both count 7 and count 8. Hopefully it's instructive. And that's why you come here, is for the commentary that actually helps understand things, because they're all talking with this in front of them and we're not. So on count 7, which the court's like, I get it. It argues that on or about January 29th, 2022, the defendant with intent to deceive or defraud presented or caused to be presented any oral or written statement or representation as part or in support of a claim for payment or other benefit pursuant to a life insurance policy, certificate, et cetera, and that the representation contained false, incomplete, or fraudulent information concerning any fact or thing material to the claim. On count 8, it says between January 29th, 2022 and August 31st, 2022, I wonder if this is the emails, that the defendant with intent to deceive or defraud knowingly or recklessly devised a scheme or artifice to obtain anything of value. The interesting thing here, though, is this would go to her obtaining the policy, because we heard testimony that she obtained the policy January 29th. It went into effect February 2nd. He passed March 3rd. So they're saying that's going to be her obtaining the life insurance policy, but they're going to have to then argue to the judge that she obtained the life insurance policy with a plan in place, but they have to have evidence to support the plan in place. And I don't know if they've shown that at this preliminary hearing. So I think that's where the court is like, okay, well, show me why she obtained the policy in a scheme or artifice, because the emails are pretty easy. She was saying things in the emails that could be fraudulent, the signature, obtaining the policy, what have you. And maybe they're going to argue that that's also what we see in her scheme to get the policy. So let's continue.
It could be the false representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there.
Yep.
Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature. I think either
Yes, there is a forgery count.
9 or 10, or maybe 11. Kano, they think 11 is the throw a fork signature on the $100,000 policy.
Sure.
So
Right.
That relates to the claim, right? Count 7 is a false claim
Right.
on an insurance policy. Count 8 is a scheme devised to get the money falsely from an insurance company.
But
Can or cannot involve a claim.
fair enough. But is it the? I acknowledge that we don't need to get into merger today, but
Sure.
is it the
Your Honor,
forged signature? on the
Please don't get into
$100,000
merger
you
today.
say?
These might be in the alternative.
It's the signed
Let's just
application on January
let it be.
29th. It starts with the application
Okay.
for the policy that issued on February 4th,
Right.
10 days before the attempted homicide,
Okay.
a month before the homicide. It starts with that signed kind of application that the court will recall there was no way for the insurance company to contact Kouri Richins. Rather, they can only contact the defendant, right? The defendant used her business P.O. box. The defendant used her email. The defendant provided an improper phone number.
Okay.
And so submitting that application begins the scheme.
Got it.
Then the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is I'm going to submit false application for insurance on Kouri Richins' life, I'm going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is...
That's what I said.
Allegations regarding...
So the 3
Kouri
forgery
Richins'
counts have different
signature
days.
On the application.
June 29th, August
$100,000
2nd, and January 29th.
Correct, Your Honor. That's the policy of Exhibit 17.
What is...
The August
9,
2nd
10?
and January 29th.
9 is the
Oh, 9, 10, 11.
fraudulent
10, 11.
bank statement that the defendant provided to Ironbridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. That's the cut. Those are the cut and paste job
Got it.
statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in...
Yes,
5.
same dates, June 29th. Yes,
Right? And then the forgery count of 10 is
those are
related
mortgage
to
fraud 6.
the mortgage fraud count in 6. Correct.
Yes.
Got it.
Night
Okay.
to E5.
Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good.
I'll be back. That sounds like a threat when you say it that way, Mr. Bloodworth. No, Your Honor, I'll be back. All right, now we're getting to the defense argument on
Ms. Lewis, how are you?
the prelim.
I'm fine, thank you. I'm going to address really just counts 1.
You're gonna. So count 1 is the aggravated murder. Count 2 is the attempted murder. Let's see where she goes.
And 3, and a little bit of 4. And then Ms. Nestor is going to address count 2.
Oh,
Okay.
everybody's arguing.
Tell me where you see the gap on count 1.
All right, well, here's where I see the gap on count 1. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing.
Right.
And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief
How?
as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richins.
I am here to hear how we get there, despite the text messages.
Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauber. Well, what that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richins. She doesn't know what she gave Ms. Richins.
Ma'am.
Whatever she gave Ms. Richins has been through at least 3 people before it came to Ms. Richins.
She fixed her husband a drink. Later that night, he went to the coroner's office, and then they tested him. Your Honor, we don't know if they actually gave Kouri fentanyl. Ma'am, if there was nothing in the victim's system, we got a different situation. But
Ms. Lauber got it from somebody,
Okay.
Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we
they never
don't
cooked
know
it. We don't know if
what
the
was
blues
given
were actually what they said they were.
to Ms. Richins.
I don't
Look at her
disagree
smile.
that we don't know. But knowing is not the legal standard that I am required to apply today.
Correct.
So tell
This
me
is an
why
argument for the jury.
Ms. Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law.
It's enough for prelim.
that the stuff that she provided was fentanyl.
Well, let's look at the distribution counts and examine that.
You were just talking about the murder count. I don't love the distribution counts.
Yeah, we can't do it. All right, go ahead.
So looking at the distribution.
I don't love the distribution counts.
So Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with insane narcotics, but with controlled substances, is consistent with street fentanyl.
Right.
Blues, he said.
Okay, here you go.
He talked about, okay. He talked about blues and green, but anyway, we won't get into it.
I was trying to remember if this was in the record or not before I said it out loud. So I
mean, everything's kind of in the record. It might just not have been said in court.
But I have never seen a distribution case where we don't have anything that was distributed.
You mean a preliminary hearing or a trial?
Where it was
two very different universes.
Where it was not recovered, tested, etc.
Personally, neither. Okay.
Gosh, my white balance is hating the green. I've got to get off of code green, you guys.
But
just for my own sanity.
I don't think just an individual who's a drug addict saying, "I thought I gave fentanyl." I mean,
doesn't that form the reasonable belief, though? I mean, by all accounts, Carter Lawler knows the difference between a controlled substance and not.
Right.
Well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some experience with it.
Detective O'Driscoll testified that she said
the judge is like, ma'am.
Initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug.
She didn't say she didn't know anything. She said she didn't deal it.
These are great trial arguments, but I question whether this would be sufficient to these concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
I mean, I understand your position.
And this is where the defense runs the risk of potentially tipping their hand too much and showing what their trial arguments are, because the judge is reminding her, these are good trial arguments. These are trial arguments, but that's not the standard here. I am the finder of fact. And come on now. You're not, this is not going to persuade me, given the standard that we are trying to meet at preliminary hearing, which is not beyond a reasonable doubt. It's not to a jury. It's just PC. Is there PC here? And that is the question.
But I do think we want to, for the record especially, Detective O'Driscoll testified that he cannot say with any certainty what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl. What happened to them after February 25th? I mean, the third ones were allegedly received after Mr. Richins' death, which is interesting.
That's not charged, though.
In terms of what
there's only 2 counts charged
for, and I think, and again, maybe a trial argument. It's interesting.
Counts 3 and 4.
That was the purpose of these pills.
They have charged Kouri Richins in counts 3 and 4 with distribution of a controlled substance. These charges have modified a little bit. Count 3 is for March 3rd, which is that she distributed it to Eric Richins. Count 2 is February 14th, again, that she distributed it to Eric Richins. And I don't know the elements in Utah. She hasn't gotten into them, but that's really the heart of that distribution of a controlled substance. I would need to pull the code in Utah to see if giving it to someone to take it to one person is enough to count as distribution here, or if there needs to be more to those elements, but that's what the state has charged.
They were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills. And he does not know if those pills were given to Mr. Richins, and if they were, how they were given, who gave them, did he take them himself. There isn't any evidence as to that. And
there's no evidence he took it himself.
And the very low standard we're looking at here. I get it. But that would be...
To be clear, the court's position is based on an application of the standard, not because I have an independent belief of what did or didn't happen.
I didn't mean to imply that it was your personal...
Don't impute that the judge has a personal belief, yes.
And your application of the standard.
He's not happy.
Our position is still that there needs to be something more. When you look at everything that's been presented as evidence in this case up to this point. And particularly
On what
on
element?
the distribution count.
Which
I
one?
think it's
3 or 4.
well to both, but there's additional, of course, problems with the February 14th
Right.
distribution.
Would if there is evidence sufficient to support a reasonable belief that Kouri Richins put some drugs in a drink and handed it to Eric Richins, there's probable cause for the count 3, right?
Yes.
Okay.
You're right.
The defense attorney goes, yes.
I think I've made my argument on that. And I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Karrington's testimony. I understand that, but nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
The motive would provide some foundation for intentionally or knowingly.
Yep.
We put it differently. If there was no motive,
It would be a
the
better
inference
argument.
would be harder to draw.
Correct.
Yeah, you're-
Okay.
I think that covers what I have in our record on that. I don't have any other questions, but Ms. Nestor will talk about counts
She's like, I'm going to
2 and then
sit back down, Your Honor. Thanks so much. I tried.
And she'll
Bye.
address the plan.
Okay.
We're gonna
I think I understand your position.
We're gonna sit down now.
Thank you.
Thank you.
Yeah, there's not a lot you can do there. There's probable cause here. I mean, this isn't the wild thing that would happen here is for this. The wild thing would be for this not to get held. Well, that's wild. Let's see. As the second defense attorney is getting up to make their argument, the feed is just cut. That's interesting. Let me try to look for another option here real quick, because not only are we apparently caught up to real time, but real time is not helping anyone out. Let's see. No, that's there. Let me go see if we have anything else. Otherwise, we might just go to questions and wait for this to come back, because I don't know what happened and the feed might have gotten cut while those arguments were happening. Y'all give me 1 second in real time while we try to figure out. It shouldn't have gone to lunch because this is on an hour delay. So for those of you that are like, well, it's lunchtime there, this feeds on an hour delay per the court's order. So it shouldn't have gone to lunch. I wonder if they got hit the same way we did yesterday. And if they're having trouble with the feed. That's pure speculation. Please do not let that run rampant. Let me check a few things real quick, because streaming is dynamic, and then we'll answer some questions. And go from there. I think court is already over for today. So you guys are going to have to give me just one moment as we enjoy the fact that live streaming is dynamic. Let's see. And we'll go from there. So let's see. Court should be done, which means we should have a full feed from that. And let's see. Nope, this is not. I don't have this feedback up, but I think there is another one. Give me 1 second. As I'm seeing on Twitter that Recovery Addict posted a feed. So let me go to that post and go from there. I don't see that KUTV has put up a feed yet. So with that, we don't have a feed from KUTV. Let's back up and see what happened here as we pull up this feed. But thankfully, a few other folks have feeds, which is very, very helpful. So Let's see. Art by Julie E said, EDB, do you have a Kouri Richins playlist so I can catch up? Yes, we do have a Kouri Richins playlist on the channel. Most things you search on the channel, we will have a playlist for. And if we don't, it's because we have forgotten. So to do it, but we will if you put it in the comments. All right. Let me go to that feed real quick, and we will zoom back to court. I have no idea why the break on the other channel, but you know what? When folks are in court, we have the ability to have choice, and I appreciate that so much. All right, let me gain this audio up real quick. We will get to the end of this attorney's argument and pick right up where we left off. A reminder, replay crew, love you. Everything's timestamped down below so that you can go find it when there are interruptions. So, Swim Gal said, I wish this was live streamed. It's not a trial, preliminary hearing. Wish it was live streamed. What's the reason for the delay? Court order. The court order is that it has to be delayed. So with that, there is a delay. Let's see. We are, and for those of you that are getting news alert as court is ending, we are going to be yeeting spoilers from the chat. Court is ending in Utah, but the court has ordered that any feed be delayed by an hour minimum. So there are going to be delays. We were caught up in real time, or just about real time from the hour delay. So we are going to have to go pull this back, but that is what the court has ordered. So let us get to where we hit the interruption in the other feed and go from there, with all the thanks to Recovery Addict for putting this feed up on the YouTubes. All right, let's go back to court. Because live is dynamic. All right.
Just put some drugs in a drink and handed it to Eric Richins. There's probably
gain that
cause
down a
for
little
the
bit.
count 3, right?
Yes,
Okay. All right.
you're right. But I think I've made my argument on that. I still think that anything that happened from any of the other witnesses, of course,
All right.
goes any further to show anything about count 1. It goes to the motive, which is an element of count 1.
All right, we are
especially
finishing up.
Ms.
We are finishing up
Karrington's
the
testimony, I understand
argument
that.
that we just heard.
But
So yes, there's a little
nothing
overlap.
that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly.
Yeah, it would. That's what motive
Put it
does.
differently, if there was no motive, the
Ay,
inference
ay,
would be harder to draw. Correct?
Yeah, you're correct.
Okay.
You're correct, Your Honor.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial counts.
Okay. I think I understand your position on 1 through.
Okay.
Thank you.
Thank you.
Good morning, Your Honor. May it please the court. If the court would indulge me just a couple minutes. I know you're so familiar with preliminary hearings. You do about 1 billion of them a year, probably.
A
But
billion
I just
might be
wanna
an
talk about
exaggeration.
what they are and what they mean to this system and to my client.
Ma'am, if you are going to give us a history lesson in what a preliminary hearing is, you are going to lose me so fast. So fast.
So, Utah is a state that has
Yes,
decided.
Utah is a state. What I don't understand is why you are giving me a history lesson in mens rea and not arguing your case as I channel the judge from Legally Blonde. You do not need to give the judge a legal lessons on the lawful law. Just argue why this isn't an attempted murder or not.
Not not to employ the grand jury system to determine whether someone should be prosecuted for a felony crime. Utah has decided to place the entire power of whether someone's going to be dragged away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table.
These people?
It's their power to fill out.
Ma'am, a court still has to decide it. The elected. I'm just gonna let this fucking roll.
Information.
I have some role in the process.
Yes. I'm talking about before they get to you.
The judge is like, Your Honor, these people dragged this woman out of her home to put her in custody and prosecute her. Look, ma'am, this argument may be better made for some of the other cases I cover on this channel. This is not the one. This is not the one. And this judge is not the judge, and now is not the time. This argument would never be happening if this case wasn't being streamed.
Away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table.
These people.
It's their power to fill out an information.
I have some role in the process.
Yes.
Yeah, a very critical one.
Before they get to you.
Bloodworth is
Not to that part yet. You're
chuckling.
jumping ahead of me. But what brings them to you?
The woman in blue sitting behind Bloodworth in the black suit with the blue shirt is I believe the elected prosecutor for this county. So
Is the people sitting right here, and it's their opinions, it's their
people.
Beliefs.
They're elected.
They're not a grand jury. They're prosecutors. They do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping.
We
And
know.
Instead of delegating that to a grand jury, people in our society that come together and close doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper.
dude, judges, I think oftentimes can be much more stringent judges of the evidence than a grand jury is.
And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime.
Ma'am,
It's enough to charge you.
you are not teaching civics to third graders.
But that charging decision does matter. And it's going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate. You the gatekeeper. So we believe very, very, very strongly.
I believe, ma'am,
that the
that
charge
you should watch Ann Taylor's amazing work in Idaho. I think she is great. I think she has defense attorney goals. Of
attempted murder.
Filibustering
has
at this
not met
point.
The lowest standard, even, of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me in that.
I agree with everything you said about the law. What is the essential
The court's
elements
kinder than I am.
to that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable
Freaking history
inference from?
lesson.
Causation. 100% causation.
Okay, how?
So, in order for them to establish an attempted murder,
Right.
they have to show that Ms. Richins took some act that caused someone to be in danger of death, right? She had to have caused something that put them at
Giving a
risk,
sandwich to
right?
somebody?
Whether they actually died, obviously it's attempt, right? So I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes.
Sure,
but I
walk us
think
through.
it shows so clearly
How did
that
we
they
get here?
cannot make the connection. And it's indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones. Okay?
Well, your client's phone is missing some shit. She didn't rehome it though. She did not extract it with the FBI. She didn't destroy it, to her credit, but a bunch of shit's been deleted. So I would love to hear more about what is in the Celebrate extraction that is unrefuted evidence that shows that there's no causation on this attempted murder. Because right now, Mr. Bloodworth is all of us. And don't worry, chat. I've seen a number of you asking if Bloodworth is the best legal name. I'm going to put up a poll later on in this stream and ask about a few attorney names.
In Exhibit 6,
I just want to hear what's in the exhibits that she thinks
text between Eric and Kouri
matters.
That say exactly their communications that day. I want to go back to the very beginning, which is the receipt.
When she told him to take a nap?
Exhibit 66 from the Mirror Lake Diner. It shows that Kouri's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich. And
the other defense attorney, by the way, who was killing the tie game yesterday, still killing the tie game today. We absolutely love his tie game.
And an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich, and I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. If you eat it quick or you don't eat it.
Ma'am.
So she brings an egg sandwich home.
Even Kouri can't keep a straight face with the over hard egg sandwich. 2 hours later is going to be a problem. The egg is not the issue. Kouri, look at Kouri's face. She had, look at her. She had to put her head down.
But I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. If you eat it quick or you don't eat it.
Face.
So she brings an egg sandwich home at 9:07. This actually hasn't come in, but
And you can't argue
the
it.
court could take judicial notice because of the address on Ms. Karrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe, and I don't think the DA will, or the county attorney will dispute that.
Nothing in Camas is very far away.
Nothing in Camas is very far away. So it's about a 5-minute drive from the cafe to their home. So best case scenario of her credit cards being swiped at 9:07, she's getting home around 9:15 in that area, maybe.
Is there any evidence that she actually went home?
Correct.
Well, I'm asking.
There
He's
is.
asking.
On her phone, the printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way to the house, and that's from her home.
Okay.
So she was at home.
When?
So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly.
Ma'am,
So it is.
it's an over hard egg on a bagel sandwich. The ADHD friends in the chat who have made themselves an egg sandwich and then literally forgotten, and then 4 hours later were like, "Oh my God, did I eat?" We're all still here.
It's perfectly possible and just as inferential that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Kouri and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm going to go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right? So
No.
it is perfectly consistent with Kouri Richins' statement to her friend. They ate breakfast together, which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food.
How do you know that?
So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by Eric.
Can you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
No.
They just talked about her telling her friend lying that they were together when they ate.
So
No, they didn't say that.
I just want to make sure I'm not missing anything that you're seeing. Quote.
Mm-mm. 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 That's not what the state said. The state said that she texted her bestie after the conversation started because Eric was texting his friends that he like almost died and broke out in hives and thought he was going to go to the hospital. Kouri texted her bestie lying, according to the state, that they both worked from home together and that Eric never broke out in hives and he never took an EpiPen. But we know that Eric didn't start feeling badly till after Kouri was at her lover's house, because what we have in the text messages is Eric saying, I don't feel well. If I keep not feeling well, I'm going to go to the hospital. And she says, take a nap. So no, the defense is not accurate in that statement because that's not what they said. And the judge is like pulling up the exhibit going, nobody said that. Because nobody said that.
Forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day and Eric.
Your Honor, I didn't know you'd be cursing. Hold on. Let me let you read in the entire text message from the bestie. The state refrained from reading in, I didn't even make him a fucking sandwich. Where is Cartman when you need him? Okay, the judge is going to refute the defense with Kouri Richins' own text messages to her bestie.
Missing anything that you're seeing. Quote. Forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she.
I didn't even. So here's the context I'm hearing from everything we know from filings and what we've heard here. Eric told his friends that Kouri made him a sandwich and he got sick and like, you guys almost lost me and that kind of stuff. That's in other filings. The defense is arguing they ate breakfast together. She brought it home and then gave it right to him and wouldn't have even been able to put anything in the sandwich and blah, 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 because she's arguing against the attempted murder count. And the court is saying, well, she's texting her best friend. I didn't even make him a fucking sandwich that day, which the prosecution left out when they argued it, saying that Kouri told her friend, we both worked from home that day. It doesn't say they ate together. It says they work from home, but Kouri's telling her bestie, the boys are being dumb. Like the husbands don't even know. I didn't even do this. I didn't even do that. And the reason the court said, apologies is because he needs to say, get in the car, Elizabeth. No, the court said apologies because he was going to say fuck in open court, but it didn't shy away from it. We're here for it.
Hadn't seen the time. She hadn't been exposed to any of
Hey, folks, I need you to take a deep breath.
Oh, the prosecution's laughing. Somebody at counsel table is laughing. Hold on. It looks like the woman with the red hair. Emily, are we doing a full forensic deep dive into this preliminary hearing? Yes, this is now an episode of whatever it is, but the text messages. So the woman with the red hair who's behind the prosecution's table, but I can't tell if she's behind.
I can't tell if she's in front of the bar or behind the bar or not. Some of you are saying that might be the victim's sister. Then might be behind the bar, behind the prosecution table. So I can understand why they might be a little bit more upset with the defense arguments. So let's take a look. For who said this looks like my pause face. Okay, let's keep going.
8.
So I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working
The fucking
from home
idiots
that
being
day,
Eric's
and
friends.
I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't been exposed to any of the
Folks, I need you to take a deep breath. Is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
Sure.
But she admits she got it at Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no
Nothing says they ate it together.
debate. She was not there at lunchtime. That didn't happen. So,
Right.
so that's clearly a mistake. So she leaves the house at 9:41.
It looks like the woman in red is closer to counsel table in front of the bar and is vigorously moving her necklace, which actually is exactly what I am doing in this moment.
And is gone for the rest of the day.
It's quite an
Eric
argument.
drives to multiple other locations after she leaves.
Do we know, help me out, do we know that? Or
Yes.
was he doing the estimating from home?
How do we
This
know
was unclear
that?
to me from the testimony.
So in the Celebrate
Where?
exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's making business calls ever since Kouri left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls.
You have no idea what time he ate it.
Then he texts Kouri at 11:27 and talks to her about some soccer fees that the boys owe.
You don't know what's on that
And then
call,
says a few minutes later,
except from your client.
so between
So, okay.
11:27, he's talking about soccer. At 11:33, so he hasn't seen Kouri now in 2 hours. He says,
You don't know that's on that call.
I'm going to go lay down. If I don't feel better, I may go to the hospital.
Right.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, he says, I wish you were here. And she's like, I would cuddle you. So that is very misleading.
She's texting, I would cuddle you from her boyfriend's house after her husband's like, I don't feel well. I think I should go to the hospital. And she's like, take a nap. When is this?
Pull that statement out. And I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30.
How do you know?
At the latest. So in that period of time, he's been running errands, doing business calls.
There's no evidence of
texting
that,
Kouri,
by the way.
very benign, normal day-to-day texts. Nothing about, I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic text, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time I'm sorry, that's not before. I withdraw that. Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food, leaves food for Kouri in his truck as they go back to the game because Kouri is running late. And that
Kouri's running late to get to her kid's soccer game. Was there traffic on the way back from the boyfriend's house?
that's the day. That's the day that they are now saying
you missed a
that
part.
that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever, that he was, if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours.
We don't know when he ate it.
He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Kouri that day, that he felt bad up until 11:33
Other than the
is
sandwich.
the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th looking backwards?
No, that's not what he
And I
asked.
think that's a really important inquiry, because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, OxyContin. And as a matter of fact, he told, wait, I have to think if this is in.
Can I ask you some specific questions about
Yes.
So let's take it one piece at a time here in terms of events after February 14th.
Yes.
And you are allowed to look at the defendant's behavior afterwards to look at consciousness of guilt or motive. They're arguing it in the Donna Adelson case. Did she flee? Is that what she was doing at Miami International Airport? So the text messages after Eric Richins got sick on February 14th saying, I need something stronger, you're allowed to consider that, and you're allowed to consider deleting things of consciousness of guilt. The judge is going to do it. I don't need to do it. I'm sitting here trying to keep my mouth shut because the defense attorney is defense attorneying. I don't find her arguments tremendously persuasive, and I don't know how with all of those text messages you get up and look at a jury and go, ladies and gentlemen of the jury, nobody eats an egg sandwich an hour later. The horror. Ma'am, if that's the argument that you're previewing, the state is thrilled.
In your view, can the court consider Ms. Richins' text messages to Mr. Grossman on February 15th?
Yes.
Can I consider them at all?
Yes.
Can you consider them?
Yes.
I think you can consider anything you want to consider in terms of.
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider under these set of circumstances. And it's often a difficult slalom course to ski. We did some of this yesterday morning, trying to get a sense from the defense of whether or not the court can consider things like the text message quote, if he would just go away, end quote.
So,
or as evidence of an inference that she wanted him not around anymore.
But that could be divorce. That doesn't have to be death.
But it's a prelim, ma'am.
We're not at trial and I'm not a jury, and so I have to contend with black letter law. Let me just get this out. I really am genuinely interested in your response.
It's like, but you keep
arguing.
arguing.
There are multiple credible inferences that can be drawn from this evidence.
But that's not what we're here for.
Innocent. But I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness.
She tried to give the judge a lesson on what the law was at prelim, and he's like, let me break this down for you.
Or credibility of the inferences.
He's right.
I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And So when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting the urge to jump up and say, and that just shows she went home to give her the sandwich.
Right.
That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards,
Right.
the text messages, her statement regarding
Right.
ordering at lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive,
Well, I
and it's
got that.
February 15th,
But that's not my question.
right? So how does the
The judge just said
statement
that's
on
not
the
his question.
15th relate to something that didn't happen? And she's talking
How
about
does
in
it
the
not?
future, right? Like,
I guess the question is, if on February 15, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
I know the answer.
she doesn't say he should be dead.
I know, but we're talking in terms of reasonable inferences.
Ma'am, he's asking you for the evidence code. He's asking you for rules of evidence. He's not asking for further argument. You have to listen to the words the judge is saying to you. He wants you to say, actually, Your Honor, under evidence code, it would be inappropriate to consider that text after the fact to prove something that happened on the 15th, because that's what he is asking for. And what she is giving him is, but Your Honor, there's multiple interpretations. It's not like she said, this. That's not what he's asking for, because the only interpretations the judge could take are the interpretations that are most favorable to the prosecution, because we're at a prelim.
It's, criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look at text that you wrote about your spouse, years later, and put it all in.
It is the next fucking day. It's the next fucking day. It is the next day. She is punting all over this courtroom right now, and it is just... The judge is like, I need you to tell me if I can consider this. And she's like, as defense attorneys, cell phones are terrifying.
Ordering at lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive,
Well, I
and it's
got that.
February 15th.
But that's not my question.
Right? So how does the statement on the 15th relate to something that didn't happen? And she's talking about it in the future, right? Like,
I guess the question is, if on February 15, she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
He tells you what he
she doesn't
wants.
say he should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look
You've got
at
no
text
answer.
that you wrote about your spouse, years later, and put it all into a cone of literal death threats when you say, I wish you'd leave, he's getting on my nerves, I want him to leave the house, I'm going to leave him, I want to
That's not what those text messages say.
divorce him. They put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship. But to take a context, one single text, and to say that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all.
Well, he also gets sick.
I don't think that is a connection.
So I hear you saying you can consider a judge, but it doesn't have any.
Yes, the judge was looking for the rules of evidence, and she said, basically, there's no rule of evidence that keeps you from considering it. You can consider it. I just don't think you should. And that's not going to be persuasive.
Wait.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend.
This is not going well for the
That's
defense.
what we just said, where she has not seen yet the time, like she hadn't had an opportunity to review the timing. So if she maxed up lunch and breakfast, but everything else in there is consistent.
She admits
with
to
what
giving him the
happened that
sandwich.
day.
What about her text message on or about February 26 to Carmen Lawler saying I need something strong?
Again, that's after the 14th.
It's a backward-looking statement, though. At least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she had just recently got something from her. So
Right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
Or more specifically, not necessarily referring to what she got on the 11th,
Right.
but it could be from the 25th.
but I mean, you have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not.
You're ignoring that text message with CL where she asks for something stronger, and you're ignoring all the victims' text messages saying that to his friends that he almost died, and you're leaving out there's a whole bunch of shit that's not being addressed.
Enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, I mean, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
This is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap.
He was trying to ask about this.
They must have done it again. That's the whole reason we have 404B, is to prevent that.
But
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions and the lengthy or the deep body of case law
404B is not going to help you here,
exceptions to
ma'am.
the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those
One of those exceptions.
Right. Well,
In your view, does 404B work backwards or does it only work prospectively?
it only works prospectively, in my opinion. But the analogy as
Based
to why
on
this
what?
is such damaging and risky analysis can be found in that rule, and baked into that rule that our legislatures and our Supreme Court recognize that
Tell
that's
me about the
very, very
Magna Carta.
dangerous to base a prosecution on somebody.
We'll talk 404 in a minute.
Used drugs once before in their life, they're probably guilty this
That's
time.
not
That's
what's
the whole thing we're trying to avoid in our system, and that's the whole basis for their argument on the attempt.
It's not what's
the entire
happening.
basis, because they know they don't have proof. They don't have medical proof. They don't have. We heard testimony about allergies. We heard about all of that. So, I mean, there's innocent explanations for everything that happened on the 14th. Every single thing.
But that's not the
that
standard.
doesn't lead to a reasonable belief. They're 100% relying on an action and conformity argument.
I don't think we heard the admissible testimony.
they're not.
But I take your point.
They're arguing a motive argument, not a conformity therewith argument. That's not.
I'm sorry. I'm trying really hard to separate it in my brain.
I understand.
I'm going to need an egg sandwich after
I
this.
actually think it's included in the,
Oh, it's almost 3 o'clock my
I
time.
believe it's included in some of the exhibits.
Bagels are gonna be
but we'll just
closed.
leave it alone just in case I'm wrong about that. I can check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge,
Yeah,
the attempt charge doesn't have probable cause.
Oh, okay. I reversed myself. Apologies. Sustained. The other attorney argued the attempt charge. Or the distribution charge. She's arguing the distribution charge as to February 14th, saying there is no evidence anywhere that Kouri Richins gave Eric anything that was an illegal substance.
The distribution charge doesn't have probable
I
cause. They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast or lunch.
Well, I think her location about her being home all day is one of the things they need. We were working from home that day.
I mean, that's easily provable. So it's not like when she's talking to her friends, she's trying to remember.
It's easily provable that she wasn't home all day.
The day back, a few months later, and she got part of it right. I mean, and part of it wrong. And I just don't know if it's just.
You're telling me she didn't remember that she drove an hour to be with her lover on Valentine's Day and she was just confused about that? And she's like, oh no, I didn't even make him a sandwich. I fucking bought him a sandwich and we worked from home together all day. Ma'am, no.
I mean, how do we know that? What purpose would that be? How would that serve as a lie?
The argument is
because she was out getting dick
she's with another person besides her husband.
Oh my God.
Okay, that's a good reason to lie. Because you're with your boyfriend and you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
They're not talking about consciousness of guilt for killing your husband. They are talking about whether or not she's showing consciousness of guilt for trying to kill her husband on Valentine's Day, less than 12 days after a new life insurance policy that seems to be forged went into effect. The fact that everyone's ignoring the life insurance policy right now is killing me, but the life insurance policy that went into effect on February 2nd gives us a little bit of insight into what was being planned. I'm going to 404 in a minute if we... Oh my God. This is going to be very interesting when we get to trial. I'm trying to breathe.
Okay, that's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present?
She admitted she was present with him, and she was.
That's what I was saying. Oh, you guys, we're going to stream forever today. The judge is saying, but could it be an inference from Kouri's behavior and statements that she had a plan to not be present when she told her husband, why don't you lay down and rest? Those black-eyed peas, they tasted all right to me. Why don't you take a nap? It's going to be fine. The judge is saying, isn't it also a reasonable inference that she was setting up not being at home and coming home from the boyfriend and being like, what happened? My husband, I mean, I was cheating, but I mean, never this. Shock, awe. So when the judge is saying, isn't it a reasonable inference that she was lying to her best friend, that they were working from home all day, that it was to set up a potential alibi because she was with the lover? And the defense attorney's like, she was telling her best friend the truth. They did work from home all day. Ma'am, that's not what the cell phone data says. I can't believe you're arguing this with a straight face. To this judge, leave him alone.
Not conscious of the guilt of killing your husband. That's not.
And the judge has to sit there with a straight face and patience. The patience. There are times in the chat you're like, Emily, did you ever want to be a judge? Do you think I could exhibit the patience that this man is exhibiting right now? No. You know what my face would be saying? There's not a chance. There is not a chance. But this is not what it is.
Wanting to tell people you were hanging out with your boyfriend.
Okay, that's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present?
That part.
But she admitted she was present with him, and she was. She brought him breakfast. Okay. So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. It's a statement against interest.
Okay.
In my opinion.
Seriously.
Okay.
Also, if it's a statement against interest, then it's an exception to Rule 404.
So I don't really need to argue the distribution. You get that. All right. So the
We
only
get
other
it.
question, the only other things that we have on the fraud type arguments. I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction over.
Ma'am, I said that if you were getting on the YouTubes, you needed to look at Ann Taylor's arguments, ma'am. I never said a damn thing about Daryl Brooks's arguments. Also, each of the attorneys that went forth said, and did that happen in Summit County?
These acts, they did not establish where they occurred.
They established all those.
Reasonable inference that Kouri.
They established all those
Richins
houses were in
was
Summit
making
County.
These applications informing these schemes from Summit County.
And the houses
They
are.
have to show that. You
Yeah,
can't
they did.
just out of whole cloth make that up. There's no evidence that occurred.
Well, the standard of proof is the same for every element
Right.
of the crime, right?
But there's no evidence that was submitted.
She lives here. Her business was based here.
They
I think
did.
There's a
They showed where the business was incorporated, and they showed the bank accounts and the addresses on the bank accounts.
basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record
Okay.
that I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the
There are times where young attorneys get to prelim and forget to ask law enforcement, and did this happen in like whatever county you're in? And generally, if that is the case, the judge will look at the young prosecutor and be like, is there anything you would like to add to amend the record? I will allow you to reopen for 2 questions. And they will look at the IO and be like, and did that happen in the county of Los Angeles? It generally takes a young professor once or twice, or a young attorney. I saw a comment about law professor. Judge has full professor mode on, but it generally takes once or twice before an attorney is like, I will never forget to ask that again. But the judge is like, they asked a number of times if this happened within Summit County. So she's making the record. I think they proved
I
it.
don't see why the 2 insurance fraud counts don't merge here.
Correct me if I'm wrong. I'm seeing several merger issues in
Yes.
this information, but merger is a fact issue that's handled after
By the jury.
conviction. Am I right about that? Not at a preliminary hearing.
Not after conviction, before. You said
Before
after conviction, you meant
Is it
after
before
charge.
submitting it to the jury or after?
Before submitting it to the jury, I would
Yeah.
think.
I always do it as a pretrial motion, but
Oh, you can address merger after. That's what they did in the Josh Duggar case. What they're saying is some of these counts are included in one another, so the counts could merge. The merger counts can happen after conviction, like they did in Josh Duggar. He was convicted of 2 counts, can only be sentenced on 1. She's like, I do it as a pretrial motion. It can happen after conviction. It can happen before conviction. You can't be sentenced on each, but you can have those go to the jury.
Yeah.
I may be wrong. I may be doing it wrong.
I don't think it gets considered though at a preliminary hearing as a matter of law.
No.
Well, I think if you determine at a preliminary hearing that 2 counts are actually one act, that you cannot push forward one of them. Absolutely, I think you could do that.
Do you
But
have a citation for that? I thought it was the opposite at a preliminary hearing.
Could you tell me the
well, I think you
law?
would just argue that they can't make 2 separate counts. So there's not sufficient reason to believe that a second crime is committed because it's all one. So that's your finding, that it's you can't reasonably believe the second crime is committed because it's just one crime. Because the scheme swallows the allegation of the
Ma'am, your colleague spent way too much time yesterday talking about spitting. Today, you cannot be talking about swallowing.
filling out of the application. I mean, it swallows it. So
Take a look at this.
yeah. And then I
Damn
think
it.
on the rest we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day.
Right.
They wouldn't.
1 and 3, 2
One-
and 4.
I'm sorry,
Those are the
look at 1 and 1,
distribution.
3, getting my numbers mixed up.
Those are the
So the
distribution.
distribution counts merge into the ag murder and ag and intent, right?
No, those would be 2 separate crimes.
Tell me why you can't
Because
get them without.
Why is she arguing that the distribution of the controlled substance when it's the manner of death doesn't merge? Ma'am, stop while you're ahead.
Doing the distribution, right?
right, I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay.
So they wouldn't
then
merge.
why isn't on the one hand?
Why are you arguing to keep counts in when the judge is like, these will merge down the line? Just say yes. Because it's the manner of okay.
Forging a signature and on the other hand, making a false statement when trying to collect on the claim. Why aren't those 2 separate crimes? What is the
Because
you're
they're
arguing for?
the 2 insurance fraud charges, because that is the same offense. Insurance fraud is not 2 separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the 2 insurance
Those are
fraud
in the
charges.
alternative,
I
though.
think they merge.
You're allowed. Okay, that's an issue for
Just to
way
be clear,
later.
you think they merge because it is the same
Scheme.
fruit of the criminal conduct. That is, there was only one policy.
Right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Thank you. Can I just have 1 minute before I sit?
Of course.
Sure. I'm gonna zoom.
Just one more thing, Your Honors. And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richins could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say this will
Y'all,
not
the
go
crickets were me.
and we submit on that.
Okay, thanks.
Except I didn't hit it fast enough. I was trying to get it while she was still buffering.
Your Honor, real quick on just the merger issue, it's 2 different policies.
I'm waiting for him to be like, Your Honor, no. So he's going to get back to the merger issue. The defense attorney, to summarize, was arguing, Your Honor, there's no reasonable inference that she attempted to kill her husband on February 14th. I was waiting for her to just say, but Your Honor, happy people just don't shoot their husbands. It was not a direct and concise argument. I'm interested to see what Bloodworth has to say. We're getting back to the issue of merger. Again, this is an issue for down the road, but the argument by the defense is that some of these cases or some of these charges are the same and for the same conduct. So you can't, ultimately, you can't be twice sentenced for them, but you can get to this in a very various ways later. So
Count 7 relates to the, I think, $250,000 two-stage policy, and count
different policies.
Count 8, I think, relates to the
Different policies.
$100,000 policy.
That is not the way it is charged. I think that is, you're going to need to amend the information if you want to do that.
They can amend to conform to proof.
Frankly, I don't think there's any allegation of fraud or there's any, tell me why there's a,
What the attorney is saying, what Bloodworth is saying is, Your Honor, these go to 2 different life insurance policies. The court said it's not charged that way. At the end of a preliminary hearing, the prosecution can say, can we please amend the information to conform to proof? I proved this, can we amend to conform? And sometimes that happens if dates are wrong, if addresses are wrong. If more charges become apparent during the prelim, you can amend to conform to proof. And he can do that here if he wants to. And the judge is trying not to instruct him and has gone back to tell me why.
any reasonable belief regarding fraud related to $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richins.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's two separate diaries. This is why I'm asking.
Your Honor, I think
They were paid out at different times.
in the one diary, though, they discussed both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday.
And they're talking about the
diaries regarding separate.
They're talking about the entries from the insurance companies, not the journal of the defendant at this point.
Separate policies.
Let me ask you this, sir. Is this an issue you're considering? And so I can show it to you, but I don't know that it's a.
I understood
here.
you to be saying count 7 is based upon statements made during the process of collecting the proceeds in June.
Right.
Count 8 is the scheme to get the policy with intent to kill Eric Richins to collect.
But I thought that's what he argued. I think that's what Bloodworth argues because that's what I understood. For all of you that are like, this is far more interesting than witness testimony, yeah, the legal work that happens early on in a case
Are you referring to
is often fascinating, but also because there's no jury, people are just calling it like it is, saying it like it is, making their arguments, going back and forth with the judge. I find all of this much less restrained than you see when a jury is present. Because of course there are things a jury can't hear. There are different rules there. This is all the, the really deep dive pretrial litigation. In some cases I cover it, in some cases I don't, but we've covered this case since the detention hearing. So we're going to be covering all of the hearings leading up. And this case is just wild. I didn't think when I started today, and I thought that the defense was going to tip their hand on what they were arguing. I didn't think that they were going to be arguing that the eggs were bad. Like, I'm still shocked. Just shocked.
No known drugs, occasional cannabis use.
No,
That came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
I'm going to answer some questions while they're all looking at Exhibit 18. I turned the court down a little bit just because it's
I see what you're referring to. So this is
background noise.
Hold on a second. Let's get to the bottom of this.
Music to My Soul asked, was she charged for deleting the phone evidence? No, because there wasn't an investigation at the time. She deleted it. They couldn't prove that. They're going to use it as evidence of guilt. So they're going to use it as an argument that she was deleting things on the phone as her consciousness of guilt. And so that is part of it.
Okay.
Oh, Your Honor,
Count
you take all the time you want, Your Honor. We're here. No apologies needed. We got to hear you say fuck on the record today. It's, you are a joy. So you just let it be.
Clarification is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion,
I want Mr. Bloodworth to just say, Your Honor, with regard to that 404B instruction, do you really need me to respond? I think now would be a great time to take a pause to remind you what 404B is and that, I'm a YouTuber, so do the likey, subscribey things. I mean, for those of you that have been here a while, I've been a lawyer for over 18 years, but also content creator. So I asked for the content creator things. We're going to the rules of evidence, folks. 404. So let's go ahead and talk about 404B. 404A and 404B are dealing with things like character evidence and dealing with other bad acts. This is your section that you hear argued a lot. Is somebody being shown to they did this bad thing in the past, and so we're saying they have a bad character and now they're doing these other bad things?
There are lots of exceptions to this, but when they're arguing 404B, they are arguing other crimes, wrongs, or acts. And the prohibited uses of that is evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with that character. So the prosecution is saying, look, what happened on February 3rd, the death of Eric Richins, proves that on the 14th, she was trying to kill him. The defense is saying you're using another crime to show that she committed this crime, and that's not what it is. And the prosecution is saying, no, we're opportunity, motive, consciousness of guilt, and all of the text messages and the other things surrounding that. So it's not using a crime to prove that they acted in accordance therewith. It's using one of the exceptions, and there are exceptions, including that you can use them to show purpose, like motive, opportunity, intent, preparation, knowledge, plan, absence of a mistake, or lack of accident. So if you have text messages from Kouri Richins asking for fentanyl, and then you have Eric Richins getting really sick and telling his friends that he almost died and he thought he should have gone to the hospital, and then you have medical evidence, which is in the record, showing that the way that he described getting sick is consistent with somebody having a bad reaction to fentanyl. And then you have Kouri Richins texting the person she got fentanyl from saying, hey, can I get something stronger? And then he dies. You can use all of those things together to show absence of mistake, plan, opportunity. So he's starting to argue the exceptions to 404B. Let us get back to court and listen to the judge's delightful voice. Your Honor, I apologize for this pod face, but this is how he feels. 404B, and the judge is like, yeah, I got it. Got it.
The purpose of admitting the evidence is further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. Most of the defense's argument against bind over the attempted homicide count, as the court kind of noted, a lot of that goes to the jury. A lot of that was arguing countervailing evidence. As the court is well aware,
he said it.
The standard today is notwithstanding
Your Honor, you know that's what we're doing here.
Whether that's countervailing evidence of how quickly Eric Richins eats his eggs, or whether he goes shopping beforehand or afterhand.
He's like, I can't believe I'm saying
this. It does not apply to the court's analysis today.
He's like, I can't believe I'm arguing how fast this man eats his eggs. I can't believe that we're here.
Countervailing evidence, I find it ironic that counsel argued we hadn't heard one piece of evidence from Eric Richins. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove an MO.
Absence of mistake.
I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
She planned better for next time, Your Honor.
We've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all the reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps certainly.
I think
But
there's
don't even
PC
think
without
it's
those
necessary
arguments.
for the court to get to a probable cause determination. And, Schmidt, in discussing probable cause, references that, probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information.
Or a search warrant.
Or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah,
I mean, that's not the standard, but okay.
100 of them would issue that warrant.
Just speculation.
It's argument. Overruled. I understand the state's point.
If you didn't hear counsel's objection, it was, Your Honor, that's speculation, because he's saying if you submitted this PC to 100 judges in Utah, all 100 would find there's probable cause on this. And now is just giggling at the prosecutor. Ma'am, you argued about how fast you eat eggs. So it's not well taken for me.
Okay. It is 11:29. We're going to come back at 11:50.
No, lunch break.
My
Very
apologies.
quickly, I checked the ME report. It did reference the fact that he was positive for COVID, but it did not talk about allergies in the ME report. That's where I thought it might be, but I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you.
Yeah, I don't think he died of COVID.
11:50. Court's in recess. Thank you.
All right, we're going to zoom past this court's recess real quick. We don't have to go to the seal yet. We could just leave it on the judge for a second. He has not run off the bench at the moment. All right, we're going to zoom past the break, which I very much appreciate being able to do because, well, it's one of the reasons that I give us some time when I start so that we can zoom and get right back to the hearing. I see some of you asking if I think the judge will rule today on preliminary hearings. That is generally the case, that you will hear the judge rule same day. And that's probably why the judge wanted to take a lunch break, so that he could line out his thoughts in a more succinct form and then rule. So we're going to go to what the court has to say. We are going to then do Q&A. I imagine the judge is going to rule today. This judge has been really good with making rulings from the bench and pretty thorough rulings from the bench. So I think that's what we'll have today. And then we'll see what happens next. So we are back to court after they took a lunch break. And let's do that. All right, Your Honor. Let's hear what you have to say.
I confirm that as a matter of law, merger.
The judge went and he's like, so after lunch, I went and did legal research. Fantastic.
Back on the record. In case 231500139, Ms. Nestor, we had a conversation before the break about the merger doctrine. I confirm that as a matter of law, merger does not apply before trial. And in fact,
after conviction,
the protections provided by the merger doctrine are not applicable before trial. The trial court cannot assess whether, under the particular facts of the case, one charge merges into another until the prosecution has presented its case and the jury has convicted the defendant of multiple charges. Thus, under State v. Lopez, 2004 Utah App 410.
Thank you, Your Honor.
Right,
Which brings us to a discussion of what we are and are not doing today.
Okay.
First,
what are we doing?
What we're not doing. We are not determining in any degree guilt at all.
Oh. He's reminding the audience that this is a probable cause, and I think the judge is very mindful that because this is being streamed, he's going to give his ruling today. It's expected that he'll hold this to answer, but he's like, what we're not doing. This is a preliminary hearing that does not determine guilt. This simply says that there is probable cause to believe that Kouri Richins did what the state charged and they are not improperly holding her in custody and holding her over to trial. So let me explain to you, which gives me a heads up that he's going to rule and probably that he's going to hold everything to answer, which I would be surprised if he didn't.
Ms. Richins was presumed innocent of all charges yesterday. She is presumed innocent of all charges today, and she will remain presumed innocent of all charges through
He would
trial.
not say this if it wasn't a media
the
case.
court says today
Right.
affects her presumption of innocence in any way. Preliminary hearing is a specific thing with a specific
Purpose.
legal standard. The state's burden at a preliminary hearing is to show probable cause for each offense charged, and the court must bind a defendant over for trial if the prosecution presents evidence sufficient to support a reasonable belief that an offense has been committed and that the defendant committed it.
I like that
So
the
even
judge
though
set
the
the
Constitution
expectation.
provides criminal defendants with a fundamental right to a preliminary hearing,
This is the
the
expectation.
evidentiary threshold at such a hearing is relatively low. At this stage of a criminal proceeding, the prosecution need not eliminate alternative inferences that could be drawn from
Yeah,
the
they don't need
evidence
to
in
eliminate
favor
doubt.
of the defense. And in reaching the bind-over decision, the court must refrain from assessing whether the prosecution's inference is more plausible than an alternative that cuts in favor of the defense.
Right, there's just an assumption.
Instead, the court must view all evidence in the light most favorable to the prosecution and must draw all reasonable inferences in favor of the prosecution. And the court must leave all weighing of credible but conflicting evidence to the jury.
Right.
Here, having reviewed the evidence admitted, including the 1102 statements, the documentary exhibits that were pre-admitted, having considered the admissible sworn testimony of witnesses that testified live, the court reaches the following determinations.
And they're going to
First,
hold her to answer.
for the reasons described at the detention hearing, which remain valid today, the prosecution has shown probable cause that count 1, aggravated murder, and count 3, distribution of a controlled substance, both of which relate to events that are alleged to have occurred on or about March 3rd and 4th of 2022, are supported by probable cause. Ms. Richins is bound over for trial on counts 1 and 3.
Remember, count 2 was
With
added
respect to
later.
Count 2, attempted aggravated murder, alleged to have occurred on February 14 of 2022. The prosecution has admitted evidence sufficient to support a reasonable belief of the following facts and events. That in January of 2022, Kouri Richins secured a life insurance policy.
This is a circumstantial count, and so the court is laying out the circumstances when taken in the light most favorable to the prosecution, allows the judge to hold her to answer on this. So we are going to we're going to hear him kind of take us through the things that line up ahead of the attempt in February.
Her husband's death, or her husband's life, through fraudulent means. That she had a significant financial incentive to secure his death because she would do better under the premarital agreement if he were dead, and her businesses were highly leveraged. That on February 14, she purchased food for them both, including him. She described it as lunch in her text message to her friend in June.
You can eat eggs anytime.
She was not honest about where she was going that day or what she was doing after she left the family home. Eric had a significant reaction to something that day, sufficient to make him consider going to the hospital. The state has admitted evidence that fentanyl can cause a serious reaction. there's significant evidence, at least to support a probable cause finding, that Ms. Richins had secured fentanyl by February 11th, and that on or about February 26th, she contacted her source again and said she needed something stronger.
That part.
These facts taken together would support issuance of a search warrant to investigate whether Ms. Richins had attempted to cause the death of her husband. They would support issuance of an arrest warrant for her arrest on attempted murder, and they are sufficient to support bind over under the probable cause standard for attempted aggravated murder on February 14, 2022.
So he's holding her to answer on
The
count
court
2.
makes this determination without considering the probable cause that indicates that Ms. Richins actually caused the death of her husband.
So he's
on
not
March
taking
4th.
the murder into account.
And so
A jury
while
will
the
be able
court is
to.
considering evidence
He's taking
of
up the
statements
circumstances
made by Ms. Richins and actions
before and
taken
after the
by
action,
Ms. Richins
before
after February
the 14th.
14th. It is not that action. That is the
But not the
alleged
murder.
successful completion of the attempt. Rather, the actions and statements the court is considering that occurred after February 14 are her text messages to her paramour to the effect of, I wish he would just go away, or if my husband would just go away.
Those texts are pretty bad.
Contact with her source of controlled substances, seeking something stronger, which leads to a reasonable inference that the
Job's
stuff
not
she
done.
got before did not give her the results she wanted.
Yep.
And her statements on June 18, 2022 to her best friend that she provided him lunch. And this,
She
of
gave
course,
him the
includes
sandwich.
the evidence from the morning of February 14 that she did, in fact, buy food from the Mirror Lake Diner. Taken together, viewed in the evidence, in the light most reasonable to the state, drawing all reasonable inferences in the state's favor, this evidence supports a non-speculative inference that Ms. Richins attempted to murder her husband with fentanyl on February 14th.
Right.
Having drawn that determination, it also requires the court to bind her over trial on count 4, which is the distribution charge related to February 14th. We pause there before we get into the financial charges. Mr. Bloodworth, do you need any clarification of the court's ruling? So
No.
No, Your Honor, thank you.
We good, Your Honor.
Ms. Lewis.
No.
Okay. All right.
The court has held Kouri Richins over to answer on the murder and the attempted murder, and then the distribution charges that go with the murder and the attempted murder, because she is accused of poisoning her husband, and the distribution charges go to the poisoning or the distribution of the substance that poisoned him. So the court is binding, well, the court's going to get to the financial crimes, but is going to bind all this over for trial and hopefully set a trial date.
Count 6 and 7, mortgage fraud with respect to the Iron Bridge loan and the Boomerang Finance loan, respectively, are bound over. Counts 7 and 8, insurance fraud with respect to the $250,000 True Stage policy, and then a scheme with respect to the $100,000 True Stage life insurance policy, respectively, are bound over. What's that business?
I think you just said 6 and 7 and 7 and 8, and you skipped 5.
5.
My apologies. 5 and 6 are
She's
Iron Bridge and
correct.
Boomerang, respectively.
So the record will be clear.
Are the $250,000 two-stage policy and the scheme related to the $100,000 true stage policy, respectively.
Right, and then we're going to get to the 3 forgery
9,
counts,
10,
9, 10, 11.
are forgery counts related to the altered America First Credit Union account statement submitted in respect to the Iron Bridge and Boomerang Finance loans, and with number 11, the forged signature on the $100,000 True Stage life insurance application. Mr. Bloodworth, any clarification?
No, sir, thank you.
Ms. Nestor?
No, sir.
Okay. Let's pause there for a second.
All right,
Ms.
she's been-
Nestor, Ms. Lewis.
Kouri Richins has been held to answer on all counts. That means she's now been bound over for trial. Now there are more logistical court things that need to happen, but that's essentially the end of the preliminary hearing, is the judge binding over or holding to answer the defendant on the things that she is charged with. Now there will be more logistical things that the court will need to get to, including perhaps trial dates. So let's keep going.
I imagine Ms. Richins would like to enter pleas of not guilty to all charges.
Oh, that's right. I forget that in Utah they don't enter pleas until after the prelim. So Kouri Richins is officially entering her plea of not guilty for the first time because she had not been held to answer yet. They had waived time for preliminary hearing. That's why this went on for so long.
Does she waive reading of the third amended information?
We waive reading.
All right. The court, Ms. Richins, is entering pleas of not guilty.
So she's
to
officially
counts
pled not
1
guilty.
through 11 in the third amended information. Where would you like to go from here?
Kouri
We'd
Richins.
like to set a trial date on it.
Yay! Trial dates. Kouri Richins was originally arrested and charged May 8th, 2023. So this has been a year to get to preliminary hearing. And again, she wasn't arrested for over a year after the death of Eric Richins. So this case has already gone on since March of 2022 when Eric Richins died. The defense is now asking for trial dates. Let's go.
Had a reasonably detailed conversation with the state about numbers of witnesses, length of time, because I'm going to have some questions.
We have discussed it, and what we have agreed to, I don't know if it works with the court calendar, is we would like to set aside 4 weeks, basically the month of May,
4 weeks.
to try the case. So we think that would include jury selection. So we figured the jury selection is going to be at least a week and 3 weeks for trial.
Have you given any thought to pre-trial motion practice,
We have
discussions
discussed it.
regarding jury selection? It's going to be
It's gonna be
regarding
May.
preserving the integrity of the jury selection process.
We'll see if that's the final
We
date.
discussed it. We haven't set particular dates for motions, although I believe we thought it would be two. Yeah, we should 2 rounds of pre-trial briefing and motions, and then we need to do a scheduling one, or we need to do a scheduling order on those motions and briefs.
Can we start having those conversations regarding pretrial deadlines, maybe a pretrial conference in mid-September?
Yes. We're in trial until September 20th, though. So actually, if we could just do
Late
it
September.
after that.
Does that make sense, Mr. Lowe?
Do you
Yes.
remember?
Okay. Give me just a moment.
And now the court has to look up at all of the calendars on the wall. Most courts have like 3 months of calendars on the wall, and then the court has to look to their clerk and be like, when are we in trial? What does our calendar look like? And then they have to look at this fleet of attorneys and go, what do y'all calendars look like? And then they actually have to pick dates, which is like herding cats when it comes to whose trial schedule aligns. So I am going to zoom this a little bit.
Answer these, yeah, that's my next question. Counsel, I have a couple of questions here. If you're not prepared to answer these, we can continue this discussion. But first, rather than the entire month of May, can we just say the last week of April, the first 3 weeks of May?
We were a little bit worried because I think Easter's really late this year, and
Memorial Day is included in the dates. Some of your
right.
frying pan into the fire. More to the point, my signing week is the last week of May on Memorial Day. It could be tough for me to trade out of that.
I think we checked this. We were trying to avoid spring
Oh,
break.
excuse me. hold on a second.
Spring
Let's
break.
try this again.
Spring break's
My
also a
apologies.
cluster.
Oh, it is there again. Did I get Memorial Day twice? Is that possible?
I think one of the prosecutors just said, "Can I get Memorial Day twice?"
I did. We'll review who I pissed off to get that. Two questions. One, that will be hard to trade out of.
So what you are getting a touch on is the nuts and bolts of doing court work, but the judge says he has signing week that's normally warrant week, which can be quite a load of work, and it also can encompass taking on the caseload of other courts. These things are assigned depending on the jurisdiction, sometimes during a warrant week. They also do the overnight signing of warrants. So it can end up being a very busy week depending on how the county does that. And those things get distributed out. So judges' calendars are their own calendars, but then there is other work that like piles on top of it. And those weeks can be busy. And the judge is like, I don't know who I pissed off to get this schedule, but I guess I'm not taking spring break off because that is my week and I can't trade that week with another judge. So there's quite a lot of administrative stuff that goes in with the signing week. And I would imagine, just based on the judges that I know, that would probably be a warrant week. But all the attorneys in the courtroom are like, yep. So those schedules, the judges generally have to request time off 9 months plus in advance. So they're working on like a tour calendar. So when you look at artists who are like, we have to plan our lives like 2 or 3 years in advance to book summer tour schedules, the judges do that too. They are booking their lives years or two in advance because they don't have a lot of flexibility, and those things are all slated in, and the work keeps on keeping on. So the judge is like, that's not delightful. So now they're trying to find out when he's available.
Right.
Your Honor, you are a man after our own heart. He's like, I don't know who I pissed off to do this, but I need my Fridays.
We'll review who I pissed off to get that. Two questions. One, that will be hard to trade out of. Two, I need my Fridays.
Me too.
We understood that.
I think we took that into consideration when we decided we thought it would take 3 weeks.
Okay.
For counting jury selection. The only concern we had was about Easter week, that people traveled, and we were trying to avoid losing jurors.
People do
who
travel.
might travel over Easter. So
Yeah, but then you're going to bump
that's
into
why
spring
we
break.
started. I'd almost rather push it to the first week of June and take that day. Is it a week that you do that? Whatever. Oh, whatever it is. I don't know what that is.
So Easter in 2025 is April 20th. I think we're going to be okay.
Okay, then we could do the last week of April.
So what I'm asking, is
That would work.
If you push this to June 2025, you are going to bump this trial right into the current trial date for the Koberger trial. Can we not?
April 28th through
What about March? Can we do it in March?
May 22.
How about February? I like February. So I guess that's the dates. April
Not including
28th
Fridays.
through May
The
22nd.
idea
No
being that jury
Fridays.
selection would be April 28th through May 1.
Emily, when's the last time you went on summer vacation? I don't know. All these trials happen in the summer. No, but I'm waiting for this one. Emily, does this impact your tour schedule? Yes, it does. I am obviously a necessary backup singer to the Dave Matthews Band. Someone has to scream all the
then
time.
Let's talk. We're going to have lots of questions about how we're going to do this.
I have lots of questions too, Your Honor. Can we do this before summer tour?
We're gonna
I
have
guess
to-
that gets us before summer tour.
We'll have a discussion about whether we're doing half days each of those days for jury selection, whether we're going to ask jurors to be available a whole day each of those days.
Dude, no, you got to get it
We
done.
need to have a discussion about whether we're doing 4 veneries, 1 for each day.
Right. I do anticipate.
Your Honor, I really like you. Can we all agree that it is veneer and not venery? Please. This varies region to region. This varies by where you go to law school. This varies by what jurisdiction you work in. But veneer is so much better than venery. Okay.
Okay, Your Honor, there will be a lot of individual voir dire based on the
I imagine. And so we'll want to be thoughtful about how many we ask to come each day.
Right.
That's true. Individual veneers each day makes sense.
Sufficient resources in terms of people power and jury selection slots. Third district policy is we do this using the virtual jury selection system. You're going to have to file a motion in cite extraordinary circumstances. It's not my decision. Okay. We can have that discussion too.
Do you remember? Still stuck in my head.
Yeah.
So right now, we need to take the 9:30.
I mean, chat, it is, just so we're clear, I'm aware that it is just egregious hypocrisy on my point to ever correct anyone's pronunciation of anything. Like, I absolutely get it. I get it. I pronounce things horribly. But when it comes to legal words, I know them. Why? Because your law school professors say them to you over and over and over again. And the only way I learn anything is by hearing, because my brain is so neurospicy, I can't do it any other way. Hence the audiobooks. Let's keep going.
Block it for now on the discussion. What's that? Just say each day.
Jury selection will not be streamed or televised. So trial will start for us like right at the beginning of May, 3 weeks.
Brittany, what do we have going on in the afternoon of September 27th?
Freedoms.
Scheduling in court literally is this all the time. And they are all looking at their
Yes. Free
calendars.
Yeah.
Friendly Farm Girl, true story. The only reason I know how to properly pronounce Saskatchewan is because a dude in college. We're going to leave it there. So they are trying to figure out their scheduling. I'm going to start pulling up some questions as we're finishing in court. I support the decision to zoom in on this attorney's tie. I very much enjoy the style of this particular attorney for the defense team.
Counsel, are you available on the morning of the 26th?
Of what month? Are we talking May?
Or the 26th before, say, 2 p.m.?
Or are we talking September?
I may be in a trial. Would it be all right if I can't make it if this? Are you trying to cancel?
I'm sure it will be fine.
There's a chance we could be in trial that day. A chance. It's set for a 3-day trial. I'm sorry. It's set for 3 days, and I think it's only going to take 2. It's a trial down in Salt Lake, so we could just tentatively set it if we need us to.
I think that's for the pretrial, September 26th.
Better, in case we can't wait on a jury or something.
All right, let's avoid that day. 27th is bad.
We definitely got some code bra today. I'm going to go through questions as they're going through the nuts and bolts of court.
What's the afternoon?
Mary said, Kouri, probably, well, I deleted my text. They'll never know it was me. Kouri Googled a whole bunch of stuff with relation to how police recover things off of phones.
We could do it remotely.
Like a bunch.
We could definitely, on the 26th,
In the morning or the afternoon?
in the afternoon would be better. I'm sure the judge would give us, if we need to step out and do take a break.
I've already moved the hearing once. I'm sorry. I can't do it in the afternoon.
Okay.
He's not bumping a different case. He's like, sorry, guys, I can't bump. The other case I've already bumped.
I'm sure this is like nails on a chalkboard to all of you. I apologize.
Your Honor, don't apologize. This is half of court. Anyone who ever thinks that like being a lawyer will be glamorous, know that you're going to spend half of your time going, why can't we find a date to do a thing? The more attorneys involved, the harder it is to find a date.
So, you said something.
Oh, we do need a ma'am emoji and a bra emoji. Agreed. We need both. I'll make a note. I'll add those. The emojis are something I've created. I mean, we're going to get lots of experts and exhibitees in this case. Purple Willow Arts, I have no idea what's up with the sound. This is all from the pool feed,
and provided and uploaded onto Recovery Addicts channel. So I don't,
What do we have on the left?
this is through the pool. I appreciate that we have it.
Okay.
But the camera people and stuff are all from KUTV. KUTV has the pool for this hearing. We'll see who does it for trial.
Oh, goodness. Okay. Yeah.
They're still fighting over dates.
All right.
And Belle,
so,
I'm very happy with Remarkable.
the morning
I just refer to it as the Notebook now.
of October 22. Nah, I can't.
The court said, how about early September? And we're now at October 22nd. How's October 22nd sound?
do that. I'm sorry. My goodness. This is the problem.
The judge is
Okay, put
looking.
something out of the way.
The judge is looking at his calendar, wanting to puke when he's like, I cannot find a date to have this hearing.
Ms. Richins, I apologize. I'm thinking about this the wrong way. Ms. Lewis, Ms. Nestor, I think we need to hold an initial pretrial conference to start talking through pretrial deadlines and start talking about a jury selection.
Yeah.
Tell me when you'd like to do it. I will make room.
That's incredibly conscientious, Judge. Most judges are like, this is my schedule, take it or leave it. I appreciate that the judge is like, you know what, no.
September, Monday.
I would unfortunately be out of state that whole week.
Your
That I
Honor,
can't do this.
What about
you
October?
said you'd make it work.
It's a week.
I know, the judge needs to read audiobooks. They are still talking about things. We're going to answer a few questions.
Afternoon of the 23rd
Like later,
of September.
September 23rd, later afternoon, like 3.
We'll make it work.
September 23rd it is.
Would you like that to be in person?
Winner,
or
winner,
by
chicken
Webex?
dinner.
Whatever you prefer, we'll probably come up.
I prefer in person. Is 3 p.m. workable?
Yes.
Okay. Mr. Bloodworth.
Yes, sir.
All right. We'll set a pretrial conference for September 23 at 3 p.m.
That's their
in
schedule.
person.
That's
Thank you.
Counsel, I need you to start talking.
they're setting a date to pick more dates. That's what that is.
Issues anticipated. Pretrial deadlines. I won't be able to see around every corner. I would appreciate your input, given your experience on how you'd like to conduct this when you start talking about jury selection. To the extent I'm going to have to ask for special treatment, favors, or to the extent you want to file motions to try and secure an exception from the standard practice in the 3rd District, we need to get rolling. I would prefer that you have notice of how you're going to be taking the jury in this case as early as possible. Okay. Mr. Bloodworth, anything to add?
No, Your Honor, thank you.
Ms. Lewis?
We're almost done.
Ms. Nestor?
No, sir, thank you.
Mr. Ramos? Nothing, yes, thank you.
Mr. Ramos,
Ms.
we like your
Richins, I'll
ties.
see you again on September 23 at 3 p.m. I wish you the best of luck. Court's in recess. Thank you.
The judge is always very conscientious as people are leaving his courtroom. He has been an incredibly considerate jurist throughout this entire process. So that was the 2-day preliminary hearing of Kouri Richins. We are done. Well, we're not done here. I'm going to go ahead and give a summary. I'm going to tell you to do the YouTube things, like, subscribe. If you want to be a member of the channel, do that. If you want to stay in the loop, absolutely get the Law Nerd app, because you never know when shit's going to go sideways, because streaming is dynamic and the app lets me stay in the loop with you and lets you stay in the loop with me. We have a very busy court calendar through the end of 2024 and into the summer of 2025. Lots of live trials coming up on the docket. I am going to get to Q&A after I do a summary. So let's do a summary real quick and go from there. Let's see. I'm holding some of these questions. They're very good. And then I'm going to put up a poll because we got some great questions, and one of them I am going to poll. So at the end of 2 days, let's summarize this situation. That sounded really, really quiet to me. That was, it's because I had it turned down. We'll fix it in post. At the end of the Kouri Richins preliminary hearing, the judge held her to answer and bound her over for trial on all of the charges against her. This was not a surprise by any means. The defense and prosecution did spend a good portion of day 2 arguing over whether or not the standard of probable cause had been met. At one point, I was not persuaded as the defense started wading into whether or not the incident on Valentine's Day was in fact an attempted murder, because, everybody eats their egg sandwiches right away. And if you don't, he didn't start feeling badly then, so you don't know that she laced his egg sandwich with something on Valentine's Day. So the attempted murder charge should be thrown out. And the judge made a very thorough record about the circumstances leading up to and after that attempted murder charge on February 14th. Kouri Richins is also charged with aggravated murder, numerous counts of distribution for giving fentanyl to her husband, Eric Richins, numerous counts of forgery, mortgage fraud, and insurance fraud. Those all loop into the motives and the things that were going on with her running into massive financial troubles as her rapidly expanding house flipping business was in deep and dire and drastic financial straits. We heard a lot in this preliminary hearing that we had not heard before, including more about text messages between Kouri and who the prosecution calls her paramour, her lover, her side piece, her boyfriend, whatever you want to call it. There was another dude in Kouri's life, and she was texting him things like, if I could just get rid of my husband, ... things would be perfect. Yes, the prosecution said ... not ellipses. We're letting it go. Also, she texted him, things are about to change. Things are about to change if you can just hold in there or hang on till Friday. And Friday was the day that Eric Richins was dead. So the texting of the boyfriend, things are going to change, just hang in there till Friday, when your spouse is then found dead on a Friday is not going to be helpful when you get to trial. And we had not heard some of those text messages before. That was new information. We also heard from a forensic accountant who had information from Eric Richins' divorce attorney. Eric Richins met with a divorce attorney in October 2020 ahead of his death in March 2022. What it seems that Kouri Richins did not know is that Eric took all of his assets and his estate and moved it into a living trust, the beneficiary of that trust being his children, the executor of that trust being his sister, not Kouri, meaning the house she was living in that was in her husband's name, the business that he had that was thriving, and everything else that he had would go to his kids and not to her. We heard that in that conversation with his defense attorney, because those defense attorney notes were the divorce attorney notes were reviewed by the forensic accountant, showing that Eric had told the divorce attorney that Kouri had taken out a home equity line of credit on the home that is only in Eric's name, and that he had not taken that out. Well, Eric's signature was on that home equity line of credit, and so it was suspected that that might have been a forged loan. It is not one of the charged forged loans. Also, she took out a life insurance policy on Eric on January 29th, 2022. That life insurance policy went into effect February 2nd. The attempted murder is from February 14th. And after the February 14th incident where Eric ate a sandwich that Kouri had provided to him, after she had asked CL for fentanyl or some Michael Jackson stuff, after he had gotten very sick and texted his friends that he thought he might need to go to the hospital, texted her that he thought he might need to go to the hospital, which she responded, take a nap. We saw that she reached out to CL again and said she was going to need some stronger stuff. And then when the murder happened, we heard that it was not, in fact, a laced Moscow Mule, but it was a lemon shot that was provided to Eric, and that Kouri had made journal entries about this, indicating that she was going to need a truckload of fentanyl to kill Eric, seeming to learn from the attempted murder on February 14th. There are still a lot of details in this case that we're not going to know yet. There are the binder of exhibits, the cell phone dumps, and the rest of it are going to be telling. But what is incredibly telling about the cell phone evidence is how much of it's deleted off of Kouri's phone and how much of it still existed on Eric's phone, on the Paramore's phone, on the Bestie's phone, and on other phones. So it's very telling what was extracted from other phones and no longer existed on Kouri's phone. Quite a lot of deleted information, but the phone was not rehomed. The SIM card was not destroyed. And we know that after the investigation started knocking on Kouri's door, that she was Googling things like luxury prisons for rich people and Googling information about how police might be able to recover information off of cell phones. So it's clearly something that she was worried about. It will be very interesting to see this go to trial, and the court did set a trial date. Jury selection is supposed to start on April 28th, 2025, and the trial is anticipated to run through May 22nd of 2025. So we're going to get into Q&A. We will hear the judge's ruling again when we clip this down to quick bits. If anybody just needs the quick summary, we'll clip the judge's ruling in when this goes up onto quick bits. But I'm going to answer your questions now, and I feel terribly that I didn't get to questions and super chats and thanking everyone for gifting memberships yesterday, because the corporate powers that be yeeted our stream, and that was wild. So that is back up now, but let us go to your question. Gino asked what you all are probably thinking. Is the boyfriend going to be called as a witness at the trial? Probably for those text messages, because otherwise they are hearsay. So using the boyfriend to come in and be like, did Kouri text you this? Did Kouri text you that? He's going to be reading in the text messages of Kouri. The prosecution can admit Kouri's own statements. Those are statements against interest and statements of a party opponent. But for the boyfriend side of those text messages, he would need to come in and talk about that. So absolutely, I think he will be called, and we will get so many more called. So Leanne said EDB was also yeeted yesterday. Sounds like there was a mass trial restreaming yeeting going on. Yes, I talked to KUTV today. It was not the KUTV folks who have the pool rights. It was their corporate overlords who yeeted my stream and took it down midstream, even though it is not a proper copyright claim. I will rant, but they don't have copyright in it. It is a pool feed. So they were false and inappropriate copy claims. And I hope that if there were numerous copy claims, and if that happened to anyone who is streaming, my email is public. Go ahead and email me, because I think that YouTube should take action against companies that improperly assert copyrights over things they don't have copyrights in. And I don't think that's for or a problem to KUTV. I think that is a massive problem with their parent company, because the claims to my channel that have been cleared, well, except for the monetary claim, but the claim for my channel that has been cleared came from the parent company, again, not from KUTV, but from Sinclair Media Group, which is completely inappropriate. It, I think, is a bit usurious, and because it impacts the way that videos move forward, because it can take down a channel. I also think that it can be civilly actionable. Those are bad faith abuses of YouTube's copyright system, so it can get somebody yeeted off of YouTube, and YouTube should look into that more. But it can also become civilly actionable when you are essentially improperly and falsely striking competitors and costing them business and money. I'm going to leave it there, but I was not thrilled. But again, though, the folks at KUTV are not the folks that were doing that. That is not the issue here. It is, again, the corporation that did that. And I think it probably isn't necessarily the corporation, but most of these corporations farm out the people that are making these claims and don't care. I think YouTube needs to take more action against people who assert false copyright claims, not just when it's companies, but there are creators who weaponize that and weaponize the copy claim system. And I think when people make numerous improper copy strikes, they should not be able to make copy strikes. Or don't worry, Emily, does YouTube have to hear this from you? Yes, they do. But there should be consequences for those that weaponize the copyright content system. Don't worry. I have those conversations with YouTube, but yes, it is. If other creators had that issue, please have them. If you guys know other creators that have had that issue, my email is public. They are welcome to reach out to me. And this is a known issue today and yesterday, but it is not okay at all. But again, be clear, it is not KUTV. They have been lovely. They have been easy to work with. They have been, really communicative. They've been lovely. And they were great when they had pool for the 8-passenger Ruby Frankie stuff. They were just really wonderful to work with. This is a corporate overlord issue, but we are working on it. So yes, I really like KUTV's reporting, and I really like everyone I've had contact with at KUTV who was kind of dumbfounded that was going on. They're like, you can't do that. And I'm like, I know. The thing that's a problem for KUTV is that if the parent company is striking channels and those creators complain to the court, KUTV can lose the ability to be the pool camera. And the court will be like, if this is a huge problem where if channels are getting struck, if other media outlets are getting struck and can't use the pool feed, we'll just let Law and Crime or Court TV have the pool feed, and then KUTV won't have the pool feed. Most courts prefer to have local media have the pool feed, but media outlets can lose pool access. And this is a large case. This is local to them. I think that they would have a significant invested interest in having the pool access there. So they don't want to lose that with the court. And I'm sure that KUTV very much doesn't want the parent company fucking around to cost KUTV to find out. And I hope that ceases to be an issue today. But I will say that my response to Sinclair was pointed. Was pointed. So I'm sure if other creators have had this issue, again, my email's public. Feel free to email me and let me know if videos were taken down and what have you, and we will see what we can do. But look, man, the power of the interwebs is strong. So Sinclair can respectfully catch it. So Emily, were you going to say catch these hands? Yes, but it's like a corporation. Like may you be audited and have the day that you deserve. I mean, what else do we say to a corporation? May the IRS take a unusual interest into your business dealings. That's about all you can say. Mazzo said, will Kouri be in prison the whole time? Yes, her bail and bond was denied, so she will stay in custody. Let's see. Emily, is 11 charges abnormally high? No, not for what we're looking at in this case. The charges match the behavior that is alleged in this case. So no, 11 charges is not high because we've got a lot of different crimes. It's a great question, Colleen, but we've got the murder and then providing essentially the poisoning for the murder. You've got the attempted murder and then the poisoning for the attempted murder. And then you've got a whole financial fraud case, including the mortgage fraud, the insurance fraud, and then the forgeries that perpetrated the fraud. So the fraud is kind of the underlying motive here and behavior. And then the forgeries go hand in hand with the fraud. So once you add financial crimes in, financial crimes can can start to number more once you get into them, because a lot of the fraud cases will also have forgery stuff with it, and then wire fraud, and it starts to just build. So no, not an abnormally high. It's appropriate for the context. Aaron said Venire sounds like a trip to the OB. A lot of people had thoughts on that. Venire sounded like some type of something you would need an antibiotic treatment for. Loch Nessie said, love the tour comparison. My brain works to schedule my life around the DMV tour. Same. There's a show coming up in Kentucky with like Sum 41 and The Offspring and Slipknot. And it's like on a school night, but I'm deeply tempted to like yoink my teen out of school and be like, so what we're going to do is go see The Offspring and Slipknot. Let's ride. So I have been trying to figure out if I can make that timing work and scoot out to go see that. So you only live once, right? Erica said, can lawyers take a break for a week to chill after doing a trial, or lawyers don't get those breaks and go straight into other clients' hearings and trials? It very much depends on who the lawyer works for, how much control they have over their own life, how many cases they have. There are times where I had juries deliberating and was picking a jury and doing a trial downstairs. So literally my closing arguments happened. We did jury instructions. The jury went back to deliberate, and I took a different file, went downstairs and started picking another jury. So there was no time in between trials. Then there were times where my brain just stopped after long trials, and I'm like, I have other cases, but I'm going to need 2 days. And then there's times, depending on the cases and the caseload, where you can be like, I need a couple days off to regroup. So it really, really depends. I will say that the lawyers who have the least control over their life would be the lawyers that work for the district attorney's office and the public defender's office. Other attorneys have a bit more control over their life. So Casey Cat, we have been working on this, putting up a tentative docket. It's something that we have been working on. How to execute is a regular conversation, but yes, we've been working on that. K-Rob, good to see you, said Recovery Addict will have adjusted for the best sound. I appreciate that Recovery Addict got this uploaded. It is tremendously difficult and technologically advanced to make sure that even in a remote courthouse, you have enough bandwidth to even upload something. And so I very much appreciate that RA got the feed up today to make it available. It is just so deeply appreciated. So, and that's one of the things with being in court, is not having to wait to get the feed, because you can get it directly out of the media truck instead of having to wait for somebody else to go up. And the rest of the prelim on other channels went down. I don't know what happened, but there was a break on one of the other channels, and then the hearing just completely disappeared. So I think his channel is the only channel that has the entire hearing up in a feed. I'm sure at some point KUTV will put it up, but for now, I think that is the only channel where it exists. Patty Cakes asked, how often do these hearings rule to let off the defendant? I mean, I don't think it would be letting off the defendant, but if a case is not held to answer, the prosecution can refile the case. It's fairly rare that things aren't held to answer, but sometimes when things aren't held to answer, it should be let go. So it should just be let go. Colleen, thank you so much for the 5 gifted memberships. Swimgal said, will time served count towards her sentence if found guilty? All the time that Kouri Richins has been in custody will count towards her sentence if she is convicted and sentenced to prison. Yes, the time that she has spent waiting for trial will be counted. Slayer Nightshade said some people use the copyright system to dox people, which is why some are afraid to fight back. I know it's incredibly frustrating, but I would say anyone who's creating probably needs an email address to that's specifically for them as a creator, and at least a PO box so that they have an address that stuff can be sent to. So their home information does not need to be in that system, because it can be an issue. Jebby said, we'll have the Donna Adelson to tide us over. We've got a number of trials coming up, really. We've got the Donna Adelson trial, Sarah Boone's going to go to trial at some point. We'll see. But Sarah Boone is now representing herself. That's going to happen. So there are a number of trials upcoming. Kelsey said, defense, Your Honor. Can we just not, please? I mean, right. Nicole asked earlier, will we have an answer today? Yes. When we get to preliminary hearings, we generally have an answer the same day. I love prelims so much. Enchanted Wings said, your hair is gorgeous, wavy. Thank you. I'm trying to embrace the wavy girl hair. It's a learning lesson, but I recorded the podcast today with the members and then decided it needed a little heat and it needed just a little bit of a zhuzh, and we zhuzhed it. And then I've got some, I've actually got to get rolling soon because I've got some TV appearances that I need to record in a little bit. So there is lots more to come of work I have to do. And when those are up and live, I'll let you know. Christine says, why does the defense say, in my opinion? Because it was just argument. So that's why. Also, I wanted to put up this poll because we got a great question about whether Bloodworth was the best lawyer name. So from the cases we're covering, I am starting a poll. Who has the best name for their job? I can't type. Who has the best name for their job? We're going to go with Mr. Bloodworth because that's hilarious. And a lawyer named Bloodworth is just so good. And we're going to go with Mr. Rottenborn because Rottenborn, again, Rottenborn. And we are going to go with Judge. So those are the three that we are putting up so you guys can vote. Who's got the best name for their job? I know it's hard. These are all great. All right, there we go. So why does the defense say, in my opinion, it was argument? And they're like, but Your Honor, we can look at it this way. Let's see. Layla said she didn't say what she worked from home. I mean, I think the working from home that day was a cover. So yes, I think it was not accurate. Sean says, how does it feel knowing your audience could probably argue this better than the defense lawyer? Look, the law nerds, not only the actually legal professioned law nerds, but the non-legal professioned law nerds are attentive, are incredibly smart, and are creative. So the law nerds would slay. Hey, it's Kiki said the egg sandwich is the new muffins. I mean, this case, if we're arguing about egg sandwiches, I am going to fall over. Or I'm going to be persuaded by the ADHD power of suggestion and go on a hyper focus for egg sandwiches for months. That said, Emily, what have you eaten for breakfast for like the last 4 days? A pumpkin cream cold brew and an egg sandwich that sometimes does not get eaten in a quick succession. Elizabeth asked, did Kouri fire her attorneys? No, and her attorneys really didn't exactly quit, even though she was on jail calls calling Sky a dumb bitch. Oh, I wonder what those jail calls are going to look like after this hearing. Can you imagine? What are those jail calls going to look like after this hearing, after she was calling Sky a dumb bitch on her jail calls? But Kouri did not fire her attorneys. Her attorneys had a conflict and were conflicted out of the case. The judge was very clear that it was a conflict that had to do with the civil cases. And there was stuff going on with the civil cases that required Sky to be conflicted out. And the judge was not allowing there to be any nonsense about that. There are quite a few civil cases in this. I've covered them in other content. Some of them are now kind of paused because of the criminal complaint. But there is a case where Kouri Richins is suing the estate, suing her sister-in-law as the executor of the estate to try to get money out of the estate. And then there is a civil suit where the estate is suing Kouri under the Slayer statute. So I have covered those. A lot of that is being paused. Kouri's mom has been brought into one of them. It is a lot. This case is a lot. It is, tragic. The kids have lost both of their parents. Their families are incredibly divided, but the fact scenario of this case, you're like, wait, what? Wait, what? Wait, what? And then she wrote a children's book. Wait, what? And then she was Googling what? Wait, what? Then she was having an affair. What? Every single time there's a hearing in this case, we learn something new. And I am always like, you've got to be kidding me. Nick said this is all fascinating and this judge is great. I really do like the judge. Thank you for the compliments, Patty. I appreciate it. Lotus, the mermaid, said this argument isn't going over easy. No. That's a no. Ice Baby, good to see you. Said as a recovering compulsive gambler, 8 years, it definitely sounds like addict behavior. I mean, the purchasing the 15 homes when you are servicing that much debt was wild. So her behavior was progressive. However, what I would say, Jen, is that in most fraud cases, I never know kind of what the underlying is of fraud, but fraud cases always have a graph where it starts out small and you get away with it. And it might be the same kind of dopamine hit. It might be the same pathology. I truly don't know. But in most fraud cases, you see a slow and steady, and then there's a ramp up, and then there's a point where it comes to a head and something happens. So either they get caught, they get arrested, there is more fraud, more theft, whatever it is, but you can see it in almost every fraud case. There is kind of a slow grow, a ramp up, and then something. And those are the ones that we catch. So let's see, excited for the members only tomorrow. I am too. And since we don't have court tomorrow and just the prelim, I will be selecting the time of the members only and letting you guys know it will be an evening members only. But I'm going to try to make it not too late since we've got a hearing on Thursday as well. For those of you, I see Ozzy in the chat said, has she been in jail all this time? She got arrested in May of 2023. So she's been in jail since May 2023, but it took them from the murder in March 2022 until May 2023 to arrest her. So she's been there, since then. Jack's Snack Pack said, there's a text to my boyfriend. My dream, I divorce and come into millions. We buy and rent out our mansion, live in the guest house, have some babies, etc. She only came into millions if he dies, not if they divorced. That's one of the texts that they were alluding to with Kouri Richins that she was talking about, that $3 million house. But yes, it is a very, very well taken point by me that she did not come into anything if he divorced her or if she divorced him. The only way she got anything under their prenup is if he died. Katie, this is an incredible compliment. Katie said in Super Chat, my audiophile man said EDB is really good. All the visuals, yes, but I can also follow along just audio, #respect. I appreciate that. I try to make all of our streams, it goes very much against like the conventions of YouTube. I try to make our streams so that if you can put it in your ear, you know what we're doing and you can follow along. And if there's something you need to see, I will dude, get back. You guys come on back. Put down Stardew Valley for 3 minutes and come back. You need to see this. Because I know people listen along while they're doing other stuff. I love being along with you as you are getting shit done, working, body doubling and doing your day. I'm here for it. So let's see. Squid said, I thought the state said Eric was poisoned by a drink. It was a sandwich on February 14th. It had come out that it was suspected to be a Moscow Mule, but the state said they think it was a lemon shot. I don't know if they mean limoncello. I don't know if they mean lemon drop. I don't know. But they said it was a lemon shot. Casey Cat said, I wish the whiskey-voiced judge was named Bloodworth instead of the prosecutor. I love that. I really like this judge. I'm interested to see how this goes when it goes to trial, but we will be keeping on top of the other hearings. Of course, Thursday, we have a hearing, a big hearing. That'll probably be most of the day, Thursday, a big hearing in Idaho on that motion for change of venue. Is the judge going to rule on Thursday? Not a fucking chance. Just not a chance. Not a chance. Will that happen? But we're going to get that hearing on Thursday. We have hearings coming up in other cases. I will keep you in the loop. Bella B in the chat asked, who has Kouri's children? Kouri and Eric's children are with Eric's family. Joy Anna said, "Isn't Bloodworth the coolest name you've ever heard?" I love the name Bloodworth, but we did have to put up a poll because I love all three of the names that we pulled. Stephanie Anthony said, why does someone not plead guilty when they have all this evidence? I don't think the state's going to offer a plea in this case. What are they going to offer her a plea deal to? The state, I don't know if they've had to make a decision about the potential punishment in this case, but I guess if the defendant wanted to plead, the defendant could go into court and be like, Your Honor, I plead guilty to the sheet, and then get sentenced to like life plus life plus life in prison. But a lot of cases, especially when we're looking at homicide cases, when the option is life in prison, and I haven't seen anything indicate that this is a DP case, but when the option is just life, the defendants aren't generally incentivized to plea because you never know what a juror might do. And there's a lot of room for the defense attorneys to attack the way that the police did their job, the way that the police gathered evidence, and try to keep things out. So there's a long road to go, but the state's not going to offer a plea on this. And unlike other cases where the state might offer a deal so that they can get information, that happened in this case, but with CL, who was providing the fentanyl. They offered CL a deal so CL would come and talk about what happened here so that she can be used against Kouri. So we're not going to see Kouri testifying against anyone. She's not part of anything other than just what she was doing. So that's really it. There's no leverage that she has, and I don't think the state is inclined to offer her a damn thing. I imagine that the victim's family is also not inclined to offer her anything. Do homicide cases plea? Yes. Does it depend on jurisdiction and evidence? Yes. Yes, it depends very, very much. So I will be back with you on Thursday for Koberger for that motion to change venue. We will be back tomorrow with the Emily Show podcast on both audio feed and here on YouTube. I'll be in the chat with you at 11 a.m. when that drops. I am going over the wrongful death case in the Karen Reed case. So we're going to be covering that there. And what else are we doing? That's it for this week. We've got a members only live stream Friday. If you just got a membership, make sure that you have your notifications turned on or are in the app. I will be notifying you when we have a time for the members only live stream. That'll be Wednesday early evening. And that's what we're doing. So with all of that, thank you for being here. Thank you for being a law nerd. Thank you for riding with me today for this preliminary hearing. And that's a wrap, you guys. I will see you in the chat tomorrow. Members, I will see you on our members only live stream tomorrow. And I'll see the rest of you on Thursday in court in Idaho. Bye, guys. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.